Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention on the case out of Florida, Shanna Gardner and Mario Fernandez Saldana. We are hoping that they air today's pretrial hearing for Mario. Right now we're not seeing any feeds, but it is scheduled to start in about 15 minutes, the top of the hour, which would be 10 o'clock Eastern. So fingers crossed we can get a feed, and if not, we'll just flop around for a little bit and then we'll call it a day. So with that in mind, get comfortable. Let's get started. All right, welcome in everybody, welcome in. Appreciate you joining us today. We're fingers crossed we're going to have a stream. There's actually, both have a hearing today. Shanna is first and then Mario is second. So Shanna is like from 10 to 11 and then Mario is going to be 11 until, Judge Kite has a sentencing actually, I think at 1. So Mario was going to be like 11 until 12, 12:30. So we are hoping that there is a stream. Unfortunately, I think what happens is it gets recorded and then they upload it later. So I'm right now I'm not too confident that we're going to have a stream today, but we'll stick around for a little while and talk about other things. But let me see who is with us today. We've got Kimbers. Good morning, Susan. How are you? Good to see you. William, good morning, Moo Child. Again, thank you for the cups of coffee yesterday. Really appreciate that. Bing and Billy, good morning to you. Thank you for joining us. Shannon, good morning, fabulous people. Camilla, good to see you. Good vibes only. How are you guys doing? Let's see, we've got a couple Williams in the chat, I see. Great to see you both. Thank you guys for joining us. Crime and Rhyme, mama. I like your handle. Welcome in. Thank you for joining us. Really appreciate it. Horse Welfare, good morning to you. Karen, happy Friday. Welcome in. Hey, Jeff, how are you? Thanks for the email yesterday. I owe you a response. Ignore Me, Don't Care. Hello, hello. Welcome in. Her Legal Family, when is the trial? Mario's starts August 10th through the 14th is his jury selection. And then then it's going to go, and then Shannon starts on the 8th. Her jury selection is the week before. So Mario is going to start on the like the 16th, I guess. I have that written down. Hold on, let me find that. Let's see. So his trial scheduled 17th through the 28th of August. Originally they were going to be together, but then they got them separated. And then Shanna is going to be September 8th through the 25th. So Mario's jury selection is the 10th through the 14th, which we heard yesterday, the pretrial hearing we watched. And then Shanna's jury selection is August 31st through the 4th. So Mario is scheduled trial starting this 17th of August, and then Shanna is going to be the 8th of September. Hey, Sweet Vampy, how are you? Welcome in. Good to see you. Beach Mom, welcome in. Tao Tao, good morning to you. You Play, You Pay, how are you? Welcome in. Good to see you. Thank you for joining us. Treasure Hog, how are you doing? Happy Friday to you guys. Hey, Iowa Backyard Cam, welcome in. Green-Eyed Cat, hello, hello. All right, let's see. Joy, how are you? Thank you for joining us. Lisa, good to see you. Kelly B, your daughter needs some healing, no problem. Oh, sorry to hear that. Hope it goes well for her. Hey, Shirley Roth, Ed, how are you? You're ringing up guilty right now. Debbie, good morning to you. Welcome in. Northwest, great to see you. Ronnie V, how are you doing, lazy boys? Sherry, hello, hello. And Sharon, great to see you. Marjorie, welcome in. Bama Green Eyes, hello, hello. Crazy Mary Fitz. All right, Northwest, lurk away. Tina, how are you? Welcome in. Great to see you. Frozen Fury, how are you? Good to see you. Grizzly Grandma Courtroom Attic. Colleen, how are you? Missed you all, taking a small break from true crime, but you're back. Great to see you, Colleen. Hey, Molly, how are you? All right, I think I got everybody. So, Shelly Beans. All right, so Jelly Beans, thank you for the gifts. All right, so again, I'm hoping for a feed. It doesn't look too good. I was looking back through our playlist. I pretty much have played everything. Everything that's out there, we've already played. So I'm not gonna. If we can't get a feed by like quarter after, I may just call it a day because I don't want to like regurgitate stuff that we've already watched. And then if anything, Sarah Grace Patrick starts on Monday, but I don't think she's gonna have a jury, by Monday or maybe Monday afternoon. So we'll have time. We'll have time to revisit this. So, in worst case scenario, we just hang out for a little bit, and then hi, Paulie. Yeah, I know. Again, worst case scenario, we just hang out for a little bit, and then we'll do once the hearing is available, then I'll stream it then. All right, let's see here. So kind of the latest. All right, yesterday we watched a couple hearings. So the two of them. Oh, you know what I can play? I just realized if we don't have a feed, I could play her body cam. I did not show her body cam yet, so we can at least do that. So this incident happened February 16th, right? So Jared, he was married to Shanna, married to Shanna, had two kids. They got divorced. Then she goes and marries Mario. Jared marries Kirsten. They have kids. I don't think Shanna and Mario had kids. And then so apparently they're going through this bitter custody battle between the kids. And Jared's driving home one night, and he's got his daughter in the back seat. There's a tire in the middle of the road. He stops, gets out, and gets shot. Witnesses, nobody. Corey Richards does not have a hearing today. That got canceled. We were going to cover that. It is not happening today. At least as far as I know, that got canceled. That got canceled last night. So it was scheduled. Her restitution hearing was scheduled for today, but that got canceled. As far as we know, that got canceled. It was going to be at 1:30 local time. But if they decide that it's still on, I'm pretty sure. I got that from a very well-known source. You guys all know Gigi, Pretty Lies and Alibis. She said that it got canceled. Cuda Girl, how are you? Great to see you. Thank you for joining us. Hey, Brenda, how are you? Thank you for joining us. Yeah, so our plan was to do Shanna and Mario in the morning and then do Corey in the afternoon, but we were all ready to schedule it, and we saw that it got canceled. Anyway, we'll keep our eyes out. If it pops up, we'll stream that today. That'll be 3:30 Eastern. Cuda Girl, so I'm glad you're feeling better, much better. Yeah, it was a rough day yesterday. Glad you made it through. So, all right. So so anyway, let me continue on. So Jared gets out of the car. He gets shot. His young daughter missed her by just a few inches, so she could have been taken out too. So Shanna and Mario were originally going to be tried together. They got separated. That trial got separated, got severed, and now they're doing two separate trials. They also dropped two charges from Mario yesterday. They dropped the child because the child was involved, so that got dropped, and then conspiracy. So they dropped those two charges. So he still has the main ones. The first degree he still has. So we'll have to double check with Shan if her charges have gotten dropped. But Mario's charges, they did drop two of them, but he still faces life without parole. Actually, they both faced life without parole. They did take the DP off the table. This is not a DP case. So, DB, I hope not. No, I don't know. No. Corey Richins was canceled. Not this one. We're not sure if we're going to get a stream. That's the thing here. I'm not sure if we'll get a stream. I'm looking on all the local channels as well as the major channels, and nothing has been scheduled yet. Good morning, Betty. How are you? TGIF. So I fear what happens is that they record it and then they upload it like a day or two later. So what we'll do today is I have body cam of her being arrested. So I don't think I've shown that yet. So that's about 42 minutes. So we'll at least do that. And maybe in the meantime, something will happen with the court. But I'll wait. It's supposed to start at 10 o'clock, which is another 4 minutes. So we'll wait till like quarter after. We'll give it 15 minutes for a feed to kick in. And then we will continue to look. But we will play. I do have her body cam that I'd like to show you guys, if you haven't seen that. I think that's one thing I've not played yet. So, Cindy, how are you? Welcome in. Cuda Girl's doing better today than yesterday. Thank you, everyone, for asking and checking on you. No problem. DB, you are welcome. Red Rum for Hire. Yeah, so then there's Henry Tenon. He's the one that is accused of, he's the trigger man. And he apparently, I think he was at the apartment. He lived at the apartment, or he was a maintenance worker or something, whatever, at the apartment that Mario managed. That's the connection. So, hey, Joe, welcome in. Good morning. How are you doing? So, if you're just joining us, they are scheduled to... Shanna's supposed to start at 10, and then Mario is at 11. We're not 100% confident. We have a low confidence level that this will be streamed, but I will show you her arrest, her body cam. I do have that. I wanted to show that at some point, so this might as well be. This is probably the day to do it. Let's see here. Let me just find it. I think I have it here. Okay, yeah. So that was from August 24th. So she's arrested August 24th. Mario was arrested the day before, I think. Yeah. Oh, actually the 2nd. Oh, she's arrested the following day. All right. I have it August 24th. That could have been when it was uploaded. All right. So I won't play anything until we're just checking all the feeds to see if anything's going to kick in. We have the local channels as well as the large networks that we are monitoring, and we will give it about 15 minutes, and then we will start playing the body cam, and if a feed does kick in, we'll just end that and we'll jump back into that. So, all right, but in the meantime, I can show some... let's see here. I can show some news. We'll do some news for those that are not familiar with the case. What are they doing? Oh. So apparently 3 years ago they were seeking the DP. Interesting. They were seeking it. So that's changed. They took that off the table. All right, so I have a news clip, so we'll just give it a little bit of time just to make sure.
Just make sure you're not live.
Yeah. Yep, we're just. So I have a feeling what's going to happen is they're going to record it and then they're going to upload it later. And if they do, we will absolutely cover it and we'll stream. We'll do another stream with the hearing. And this is a trial I will be going to. I'm not going to be there every day, but I'm going to take you guys with me. And I will be there hopefully with a surprise guest. I'm not going to say anything until it happens, but it will be exciting when we do connect. But I will be there for openings, and then I'll come back home and stream the rest of the trial, and then hopefully get over there for closings. I'm just going to do Shanna. I don't think I'm going to do Mario, but we're still kind of up in the air with that. But Shanna for sure. I'm not sure about Mario. What's going on with that? Because we have Tupac starting as well. So we kind of have to make a decision, Tupac or Mario. Little Lulu, good morning to you. How are you? Thank you, Kuda Girl. Appreciate that. Kelly, good morning. How are you? Horse Welfare, thank you for the 100 joules. Appreciate that. All right, let's see here. We'll give it about 10 more minutes, and then we'll start playing some other stuff. Her body cam. I want to show the body cam, and actually, you know what? We can let's show this. This is. I'm not sure if I showed this yet. This is just kind of the arrest and. Let's see.
I'm glad to see that he's getting justice.
All right, so here's him getting arrested, or here's Mario getting arrested.
I'm glad to see that he's getting justice.
This is 34-year-old Mario Fernandez Saldana. Investigators say he is also responsible for Jared Bridegan's death in February 2022. Bridegan's family was with the state attorney when she announced Saldana's arrest. It came soon after this man, Henry Tenon, pleaded guilty to second-degree murder in the case Thursday.
Having two arrests doesn't surprise me.
Tenon used to rent property from Fernandez Saldana, who is married to Bridegan's ex-wife, Shanna Gardner Fernandez. State Attorney Melissa Nelson declined to say what evidence connects the two men or points to a motive, but says Tenon admitted he was the shooter and provided additional evidence he did not act alone.
Mario's relationship with Tenon is greater than what we know. I don't know what it is, but it's more than a landlord-tenant relationship, and it's got to be more than I use you as a handyman to come to you, to seek you out, to commit such a heinous crime on somebody, and then count on keeping their mouth shut.
First Coast News crime and safety expert Mark Bachman says there could be a lot of information Tenon told detectives.
The interesting part of it going further is they're not closing the investigation. It's still ongoing, and as far as I know, the reward is still out there for any more information. So what does that tell you? Is there another co-conspirator involved? Possibly. It's safe to assume that maybe there is some digital data that was saved and or implicates another individual other than the two now that have been charged.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the ABC News app.
All right, so that was just the arrest of Mario. Now, Henry flipped, I guess. Well, he changed his plea. You heard there that he pled guilty. He actually changed it in February. He changed it to not guilty, and he is going to have a trial next year. They set it for next year. Let's see here. Yeah, February 17th, he withdrew his plea. So, all right. Erin was able to get her hands on the witness list. Where'd you download it to? All right, so I'm not going to show this because it has addresses, but here are some. This was released last night, yesterday, the 30th. So the following law enforcement witnesses.
It's coming
Oh,
up at 10:13.
10:13. Woo-hoo. All right. Good job, Aaron. All right. We do have a upcoming. All right. We do have it. Awesome. So 10:13, scheduled for 10:13. So we do have a feed. All right. Exciting. All right. So in the meantime, here's a potential witness list. This was a defense amended witness list. Now this is for Mario. So we have Casey Bennett. And this is law enforcement. B. Burrell or Burrell, I guess. This is all. I see. Casey Bennett is the Office of the State Attorney. We have B. Burrell, Jacksonville Beach Police Department. We have ATF Investigative Research Specialist Lindsay Butler. We have Christopher Johns. He's Jacksonville Beach. We have Jason Lamont, Jacksonville Beach. These are all law enforcement, police department. JSO, I guess, right? Although it's police department versus sheriff's office. We have Lawrence Smith, also for the police department. Oh, we have civilian witnesses. We have John and Juan. Interesting. Same last name. John and Juan. Same last name. Now, they have a minor on here. Remember yesterday we heard that the defense, both the state and the defense stipulated the minor child, which was Jared's daughter. They're not going to have her testify because apparently there's video, but then the defense was going to call via Zoom another minor child. So maybe that's who they're talking about. We have Janelle, we have a George, we have a John, Lauren, Petra, Carlos. Now I'm assuming these are all civilian witnesses. Now here's another one. There's a Brianna, a Malcolm. Oh, somebody from First Coast News is going to be interviewed. Another Faria from First Coast News. So they're interviewing. Wow, Lauren Silver from Court TV. They have a couple news personalities are going to be, or I don't know if they're personalities, but they work with news and Court TV no less. Does anyone know Lauren Silver? Do we know Lauren Silver from Court TV? Who's Lauren Silver? Is that I don't know that name. Lauren Silver. Court TV. Is she joined Court TV as a digital content producer in 2023 and lives in Florida with her daughter. All right. She's an experienced, she's a journalist. Originally from New York City, Lauren Silver is an award-winning investigative journalist with a master's degree in broadcast journalism from Syracuse. She began her career as a local news producer, working in Johnston, Orlando, Boston, and Pittsburgh. All right. She's won a couple awards. So, all right. So they're going to have somebody from Court TV, Lauren Silver. There's a Rebecca. There's a Jay, a Thomas, a Janet, Vicente. Then we have expert witnesses. There's Richard Militic. He's digital forensics, cell phone record, geolocation data. We have a Catherine Ritter, PhD, neuro and clinical psychologist, I guess, or psychiatrist. Would be psychologist. General practice, I guess, I guess that's how I'm. Wow, and then that's it. That's all they're calling. So the defense is calling potentially 6 plus 9 is 15, plus another 9 is 24. 25, 26. So they're calling about 26 witnesses. Hey, Trace, how are you doing? Great to see you. Welcome in. Trace is on the case. Renee, good morning to you. Welcome in. Cuda Girl says, you're not up on this trial, but about it in the news, so I may watch some clips and catch up. We have a playlist, you guys. If you are interested in anything, go check out our playlist. We do have a playlist. We've covered about 7 or 8 hearings now. So I encourage you to go check out our playlist. And we've been covering this for a year now, I think, at least a year. So I encourage you to go check out our playlist. All right. Debbie, thank you for the eagle. Appreciate that. Hey, Glee Roll, great to see you. Welcome in. There's Trace coming in, saying hello. Snake Lady Dot, great to see you. Welcome in. Why do so many reporters sound like Chanley Painter's voice to you? I miss Chanley. We like Chanley, right? We were friends. Not friends. We were friends with Chanley.
She's a mean fiddle player.
She is a mean fiddle player. And when I say mean, I mean she's a good fiddle player. That's right. Diane, welcome in. Good to see you. How are you? Hey, Fanny, welcome in. How are you doing? Little Busy Brains, good afternoon to you. Blessings from South Africa. So we're just waiting for a feed. They said 10:13. So 10:13, they are promising a feed for us at 10:13. So let me put this in here so that when they kick in, we will be ready to roll. All right. So, yeah. So any minute now, we are expecting live feed to kick in. Shannon says, happy you get to go and bring us with you. Yay. Yes. Grampy, how are you doing? Law Lover, great to see you. Cuda Girl, that's what I was going to go watch. Was your playlist? Because I know it's covered completely so far. Thank you, thank you. JPC, how are you? Drive carefully, safe travels. Serenity, hello from Fort Worth. Welcome in. 7 of Hearts, how are you? Oops, sorry about that, guys. All right, it's 10:13. It is 10:13. Let's go. Now, this is a local channel. This isn't one of the main channels. So we're just waiting for them to kick in. So Mario's trial starts August, soon, another couple weeks. The jury selection is the 10th through the 14th. If you were with us yesterday, they talked about how the selection would go. They're going to bring in, I think, 70. They want to seat 70. Like 50 in the morning, 50 in the afternoon, but eventually they want to narrow it down and then, voir dire 70. And so that's the 10th through the 14th. So Monday and Tuesday, they're going to be just going through, I think 250. I think they said they sent out 250 applications or summons. And then his trial is going to start the 17th through the 28th. And then Shanna is going to be jury selection August 31st through the 4th, which of course is right around Labor Day, with her trial starting the 8th. So I think Labor Day is like the 6th or 7th. Yeah, I think it's the 7th. So she's going to start right after Labor Day. And we're looking forward to this. We will be there. I'll be there. Again, not every day, but I will be there. I'm shooting for openings with a special guest. And then that person may stay longer, may stay through the week. We'll see how that all works out. But I'll be coming back home and helping Aaron out with the feed and the cats and all that goes along with that. And then if I can swing it, I'll try and get back there for closing arguments as well, and then verdict. So we'll see how that works. Let's see. Grampy, how are you? good to see you. Colleen, big day. You go for your consult on your spinal cord stimulator. Wow, and planned surgery. All right. Well, good luck with that. That sounds pretty intense. We're in Florida, Jacksonville. This is in Jacksonville, Betty. This happened in Jacksonville, which I'm sure you know, but this is the northeast section of Florida. You are, what, you're like in Fort Myers or Naples? So this is pretty much the exact opposite of where you are. Granny Debbie, thank you for asking about our AC. They are coming today. They are scheduled to come between noon and 5. So it actually, we had our AC unit in the bedroom got down to, what, 66, I think, 65. It was pretty cold in there. And downstairs, of course, no AC, and it was 81 when I woke up. So not too bad. Actually, the kittens were everybody was kind of playing a little bit today for a while, but now they're all passed out again because it's like 84 here in the office. So they're scheduled to come between 12 and 5. So thank you for asking. Yes, it is definitely Jacksonville. Debbie, static. Is everyone else hearing static? I don't know. I don't know if anybody else is hearing static. D. Martin, how are you? Challenger, so it will be streamed, right? Yes, we are hoping. Oh, the actual trial. The trial for sure will be streamed. No question. The trial will be streamed. I'm sure the big channels, they've been covering it. They will definitely stream it. I'm not sure which feed we'll use. I'd like to stick with the local channel, but we'll see how that works. But yeah, no, it'll be streamed. Kathy, this is a pretrial. This is a pretrial. Their trials don't start until August and September. So yes, we are in pretrial mode right now. Kimbers is not hearing static. Okay, Treasurer is not hearing. Betty's not hearing. Okay. All right, nobody's hearing any static. All right, Debbie, that sounds like it's on your end. Thanks, guys. All right, Debbie, maybe just reboot. Sometimes that helps. That helps. And no static there, yes. Oh, let's see. Yeah, the humidity is not good for anything. My guitars, the electronics, towels. We are taking showers. It's nice to have a nice cold shower, but then it's a wet towel. But it does dry. It's amazing. They do dry. The towels do dry. So yeah, no, we're not happy about it not having. We're not happy about that. Real happy. How are you? Yes, we were promised a 10:13 start, so they're 5 minutes behind. So we're just waiting for the feed to kick in. Hey, Ruth, how are you? Welcome in. Seashell, I can't believe it's already July 31st. I know, right? Crazy, crazy. Yeah, they promised us a 10:13 start, and it is obviously 10:18 here on the East Coast. So we're just waiting for them to hit the button. Please hit the button. In the meantime, we were just going over the defense's witness list, and they're calling a court TV reporter and a couple folks from First Coast News, along with some civilians, 2 expert witnesses, about 6 or 7, no, maybe 8, 8 or 9 law enforcement, fair amount of civilians. I think a good 7 or 8 civilians. What did I say, 26? I think about 26 in total. That's what the defense is. And they're only expecting this to last 2 weeks. So it's going to be a fast trial. 17th through the 28th is what they're expecting. So, they always schedule more so that if they schedule more so that, it's better to schedule more and end early than to schedule not enough and then go over. So when they say 2 weeks, it usually means a week and a half. But again, seeing that the defense had 26 witnesses surprises me. I guess they think they can get through them in like 3 days, which is possible. I mean, we've seen trials where they can go through 10 witnesses in one day. If they're only up on the stand for, half hour, they can fly through them. Unlike Beth Silverman and Monica Cementili, where she had Robert Baker on for 2 days, I think. And then, that was crazy. That trial lasted over a month, I think. So, I guess in the meantime, you guys, please hit the like button. If you are not in chat and you can hear my voice, please take a moment and hit the like button. We have 156 likes. Appreciate that. Let's see if we can get up to 170. Let's see if we can get to 170. 170 likes. Let's see if we can get up to 170 likes before they start. Thank you guys for your, thank you for hitting the like button. Let's see if we can get that up. If we can, if you're just tuning in and you're listening, see if we can get up to 161. Good job. Thank you. Appreciate that, you guys. All right, so the big channels are not covering it, which is fine. I didn't expect them to. But we were promised a local channel was going to cover it, so we're just waiting for them to kick in. Let's see here. Seashell, are most trials going live now? Depends on the state. New York State never airs, which is a bummer. I would love to cover trials from New York City or Buffalo, Rochester, Albany. It's very rare. Like Georgia, Wisconsin, California, Florida, of course. Iowa, we've seen trials out of Iowa. The Carolinas, South Carolina. I don't think we've ever covered a trial out of North Carolina. South Carolina for sure. Mississippi, we did one. Texas? Does Texas? I don't know if we've ever done one out of Texas. I mean, there's a lot to say. Oh, Utah, of course, Utah, Nevada, Las Vegas. So it depends on the state. Massachusetts, of course, Massachusetts. I don't think we've done one out of Pennsylvania. Michigan, we've done Michigan. The Dakotas, we've never won it. Alaska, we did Alaska. Hawaii, we didn't cover that one, but we know there was one out of Hawaii. Yeah, I mean, it depends on the state. I'm excited by it. I'm glad. I like the Michigan for sure. I am very happy with the transparency, the sunshine laws, as they call them down here in Florida. CJ Sunshine, welcome in. How are you? Hey, Rich Auntie, how are you? Dropped in lurk mode, but wanted to say hi and send you hearts. Thank you for that, Rich Auntie. I love typos. That's a good one. I'm going to remember that one. Lark mold. That's a good one. Shirley, New York has a trial now of a Montreal man who took out his 9-year-old. Yeah, that's a bummer. Sherry, she was supposed to, it was her restitution. We were going to cover it. We did a description. We got a thumbnail. We were all ready to. And then I was scrolling through and I saw Gigi posted, it's going to happen. We watched Emily Baker doing her thing. And we're like, okay. She got denied. Corey Richard's team, her and her team got denied, kicking off Judge Mrazek off of they wanted a retrial. That got denied. So we were watching that. And the restitution was supposed to happen today, and we were all ready, thumbnail, description, we were ready to go. And then I saw Gigi posted. She's like, just as I hit the send button, the news came in. So Gigi, we're going to trust Gigi. She says it was canceled, that there is no restitution hearing today. So if there is one, we are ready to go. It's supposed to be at 1:30 local time, which would be 3:30 our time. So we will be ready. If Gigi is incorrect or something happens and they switch out and it's on, we'll jump on for sure. We'll do it. But as far as I know, according to Gigi, it was canceled. I don't know for when or until when, but we're ready. So I'll check at 1:30 or 3:30 our time. So if she's going to have a fee and restitution payment, we will absolutely cover that for sure. Because we're not doing anything after this. Judge Kite has a sentencing at 1, so we'll be done. We'll be done by like 12:30, quarter to 1, or 1, whenever. So we will be done, and we'll just be sitting around actually working on Lindsay Clancy, because we're going to do a recap of Lindsay Clancy on Sunday. Rich, you are larking. That was a good one. Lark mold. You are in lark mold. That was a good one. Yeah. Larissa, I hope I'm saying your name right. Larissa, or Larissa, is it Larissa? I'm going to go with Larissa. Let me know if that's right or wrong. Big shocker on Richard's denial. Yeah. That was, it did get rescheduled for the 31st? Okay. I just saw that Gigi said it was canceled for today. So thanks for that. Sherry, I wonder what Sneaky Nestor has up her sleeve now. Yeah, apparently they filed too late. They didn't file in time. That was part of the reason that they were denied. There was a couple reasons, but the judge did not find that Judge Mrazek caused, did anything wrong in that case, if you will. Oh, come on now. All right, so we're on the local channel, and they say 10:13 start, but here it is 10:25. So we're just waiting, hoping that they are true to their word, that they're actually going to show this. Glee roll in the Clancy trial. Prosecution has yet to show intent. Yeah, so we're going to be doing what we decided because it is an important trial. We definitely want to cover it and put some eyeballs on that from our standpoint. And so every Sunday we're going to do a recap. We'll just do a weekly recap every Sunday, starting at noon. We'll like do noon to 5, noon to 6, and we'll do what we did with Carlos. We'll just pull some of the top 2 or 3 witnesses, depending on how long they are, and just kind of show some testimony. That's what we have decided to do. Hey Mal, hello, welcome in. Larisha. Okay, Larisha. Pronounced Larisha. No big, it gets demolished. It's a wonderful name. It's a very unique name. I like that. Larisha. I hope I remember it. Larisha. I like to get your names right. I don't want to screw up your names. William, did we ever cover a trial in Ohio? Yes. Bianca Ellis was Cleveland specifically. That's how we, Kimbers, that's how we got connected with Kimbers. We also did, there was a pro se trial that we covered. What was his name? The pro se gentleman who he was in that party. And he,
Tyler Daisy?
No. He was at the party and they were like doing substances and he thought that she was going to do something to him, so he shot her and then he ran away and he was pro se.
Oh,
remember that guy?
Yeah.
So yeah, we have
Nixon.
Yeah. And I think he was Cleveland too. I think he might have been Cleveland. Yeah. So yes, we have covered. There's the dentist and his wife in Columbus. We're covering that trial.
People that shot the family.
The people that.
There's like a group of people.
Oh yeah. The oh God, what's the one that happened down in down by Cincinnati with the dad? The son got. It was like the family took out the other family.
Yeah.
Pike County.
Pike County.
That one. We were covering that one. I forget his name right now. I'm sure you guys remember those names. Pro se means do it yourself. That means no.
Afro Man.
Oh, Afro Man. Yes, we covered Afro Man. So yes, we have covered trials out of Ohio. Seashell pro se is it's PROSE. It's basically do it yourself. You do it yourself. You don't have representation. You don't have a lawyer. You are representing yourself. When you hear pro se, you think of Darryl Brooks for sure. Yeah, the dentist and his wife. I don't know. We did one little deep dive on it when it first happened, like a week or 2 after it happened, and we haven't seen anything since then. So Billy Wagner, thank you. Yes, real happy. Billy Wagner. Yep, Billy Wagner for sure. Yes, pro se is when a defendant represents himself or herself instead of having an attorney. Yeah, Cuda Girl. Yeah, it was Billy Wagner. It's kind of like, one family took out the other family, basically, all over a daughter, a little girl, like a baby, basically, I think. The one son was married or had a kid with other family's daughter, and yeah, pretty brutal. You had lemon pound cake on this morning, Challenger says. Nice. Teresia, how are you? Jags, you're ready for this trial to go down. We are too, Jags girl. Talk about what? No, yes, Afroman has decided to sue one of the sheriffs that sued him. And we have a document. We were going to do like a little stream on that. So he's countersuing. Cuda Girl, you listened to Lemon Pound Cake yesterday? Nice. Jane, yep, Benefield's daughter wrote a book. Remember Black Swan? Yep. Yeah, Ashley, we were at her sentencing. We did Sarah Boone's sentencing, and then a day or 2 later we did, and that was Jules and I. We went to Sarah's sentencing in Orlando, and then I drove over to Jules's house, we did a live stream there, and then the next day was Ashley Benefield's sentencing, so we did that as well. So yes, I did see that her daughter did write a book. I did see that. Yes, Sherry, they were the Hatfields and McCoys for sure. Absolutely, absolutely. Got Manners, how are you? Good to see you. Granny, do the maternal grandparents still have the child or children in this case? I think they do. I think. No, wait a minute. No, because Kirsten is still there. I mean, Kirsten's still alive, so she should still have the kids. The kids should be with her. Camilla, Daryl Brooks traumatized you so much. I wrote the judge a letter thanking her for her patience and care with the family's victim. I also sent a thank you card to the bailiffs and court staff. Wow, that's awesome. That's awesome. Horse welfare, thank you for the thumbs up. Dairy Free Nomad, when I see pro se, I always think of Miss 8 Lawyers herself. Sarah Boone, nice. Was the Sharilla trial covered? It was only her sentencing, I think, right? Yeah. Yeah, she had a bench trial, and it was just her sentencing, and it was like maybe like a half hour or something like that. It was really short. It was really short, but Kimbers gave us some video that we still have to put together something. Sherry, yeah, all the tickets are sold out to see him in the brewery here in Duncan next month. Your son is actually going to take you, but your son was actually going to take you, but he saved $75. Nice. Dogpaw T, hit the like button. All right, we are waiting for. I want to play her body cam, but I don't want to be in the middle of it. They promised a start of 10:13. Clearly, they didn't make that. They didn't make that time. Oh, yes. All right, hold on. We've got a feed. All right. We have a feed, folks. We have a feed. Here we go. All right. Thank you for joining us. And here we go. All right, so at least we have a feed, but we don't have audio yet. So, yeah, that judge for Afro Man was the same judge in the Pike County one. So, thank you, Tao Tao. Appreciate that. All right, I'm gonna love pronouncing your name. I want to get your name right. Saruchi Rose, Saruchi Rose. Please help me with that pronunciation. I definitely want to get your name. I want to get your name right. Grizzly Grandma, thank you. Thank you. You could be in your cool bedroom, but you're here with us. Aw, thanks. Appreciate that. All right. Here we go.
All right. Good morning.
Good morning, Your Honor. Patrick Rohde and Kirsten Nelson are present for Shanna Gardner. I believe Mr. Baez is present via Zoom.
Good morning.
Good morning, Mr. Baez.
Your Honor, as a preliminary matter, I've had an opportunity to speak to the state regarding juror anonymity and protection. I would make an oral motion, which I believe the state agrees with, pursuant to Rule 2.420C9A1, and 2.450C9B and C to the Florida Rules of Criminal Procedure, that the court take certain action to protect the jurors' information during jury selection and thereafter during trial. I believe the court can enter an order protecting the juror anonymity and their confidentiality and apply means that would be reasonably restrictive to protect the interest of the trial in Ms. Gardner's case.
Okay. And is the state in agreement as well?
Yes, the state joins in the motion and has no objection.
Okay. Thank you for doing that. I know Ms. Gardner's jury selection is going to be after Mr. Fernandez, but I will be able to enter the appropriate orders prior to her trial. So I appreciate that housekeeping on both sides.
Thank you, Your Honor.
All right. And so, Ms. Nelson.
Good morning, Your Honor. Kirsten
Morning.
Nelson on behalf of Shanna Gardner, who is present.
All right, we are here on the subpoena, the motion for a subpoena duce tecum in Ms. Gardner's case. And I know this has been multiple hearings. And so in review, I kind of started from the beginning, reread the information, and I knew that at least for the public portion of this hearing, if the defense could, again, just identify the sensitive nature that you are requesting that the court take in camera pursuant to Rule 3.220M.
Yes, Your Honor. And thank you for the opportunity. We are requesting that the court consider certain matters in camera because they directly relate to defense theory, more specifically, the defense's intended theme at trial. So what the facts and the evidence we believe will show at trial, and the state does not have a right to discover that pre-trial, nor does Ms. Bridegan, who may be subject to the cross-examination that would help the defense in order to develop those themes before the jury. These are constitutionally protected rights under the Fifth and Sixth Amendments, due process, and the right to confrontation. For those reasons, Your Honor, we respectfully request that the court consider in camera a defense submission regarding theory of defense and corresponding exhibits.
Okay. Is there any objection related to the not argument, but in camera examination related to those sensitive matters related to the Fifth and Sixth and due process?
Your Honor, Steve Siegel on behalf of the State Attorney's Office with Ellen Mizrahi and Christina Stifler, Assistant State Attorneys as well. On the representation that we're talking about a written submission to the court in camera based on 3.220M, the state doesn't have an objection to an in-camera submission of that nature.
Okay. And so what I intend to do, we've got to fast forward this process. Otherwise, it's going to be disruptive to, I believe, Mr. Fernandez's trial. And so the matters that I took under advisement, I'm going to consider the in-camera submission by the defense. I will have an answer on Monday, okay, related to the subpoena. And then I did need to check in with Ms. Bridegan, Mr. Clifton, on the court's resolution of EF. What is...
Mrs. Bridegan has put together those messages. I can provide them by any means that the court would like me to. If it's going directly to the court, the state, I want to provide those.
I thought I was, let me look back. I think I was going to do an in-camera inspection, yes. Correct. So she's already put those together?
Yes, Your Honor.
Okay. How fast can she deliver those?
We could probably get it done this afternoon, I would hope.
Okay. I'd ask that I will do the in-camera inspection of EFs, that resolution, if you could deliver it to the court this afternoon. I'm hoping that I can work through that.
It's a series of screenshots. It's okay if I do like an electronic file through the JA, or do you want it printed?
Is that how it is? Like, you don't have to print it.
Yeah, it's an electronic file right now. Screenshots to her phone. She'll send me the file, and I can just forward it on.
Okay. Could you do that, please?
Yes, Your Honor.
All right. Electronic is fine.
Thank you, Your Honor.
All right. So as far as the subpoena, I'm going to pass the matter over to Monday. I'm going to consider the in-camera portion of it and then resolve the remainder of the subpoena request. Okay?
Understood. Thank you, Your Honor.
Your Honor, is there going to be a separate hearing on Monday, or is it just an order coming out? I just wasn't sure if I had to be
An
here.
order.
Okay, thank you.
I don't think that you have to be here. And then if there, if there's objection to the order, then, or any other preservation requests, then I can hear those. But I'm hopeful. Mr. Siegel very succinctly said I should deny it. So I hope to get, based on the review, get to a point where I can rule. Okay, thank you.
And Your Honor, defense counsel will not be available on Monday. So to the extent that the court is setting a status, we respectfully request to waive Ms. Gardner's appearance.
Okay, that's fine. And if you want to have a member of your team, or I could just issue Monday and not set it on the calendar, I could do that. Just knowing that I'm gonna get it done by Monday. Okay, and if you all want me to come to court, or you want to address anything with me, you can add it on. Would that be more acceptable since you're of your unavailability?
That works for the defense.
About the state?
That would be fine, Your Honor.
And then Mr. Clifton, is that okay with you? Okay, so I'll make sure that I service all parties so that if you do need my time, then you can add it on. Okay.
Thank you, Your Honor.
Your Honor, I just had one more matter. We received this morning a additional filing from Ms. Gardner's counsel regarding the issuance of the subpoena ducis tecum. It was essentially a reply. I would just like the opportunity to respond to it. I can get you something hopefully later this afternoon.
That's great.
Over the weekend. It won't be long, just a few arguments that I'd like to respond to.
Absolutely.
Thank you.
All right, thank you.
Thank you.
We need to pick a final pretrial date for Ms. Gardner's case. Hopefully not overlapping with the trial. Or if you all want, I mean, you can come, we can do like an 8:30 for Ms. Gardner. If there's some last minute issues that need to be resolved.
Judge, I think that would be fine. An 8:30 at some point.
Okay. Can you all we can always move it, but can we have a target date?
I was going to suggest August 27th, which is a Thursday. Based on my discussions with the Fernandez team, we're hoping to be completed with trial by that date, so we won't be on a time crunch if we set it that morning.
Your microphone.
It's on.
Okay.
Judge, that works.
You want to come that close to the jury selection date?
Yes, Your Honor. I don't want to come while we're in the midst of our other trial.
That's fine.
That's fine, Judge. And I think the parties know that if something comes up, we can always ask for a court date.
Mr. Carodi and I were discussing some housekeeping matters this morning. We have some Zoom stipulations we're still finalizing, but if there's an issue that requires the court's attention, we should know that next week, and we can always ask for additional time.
prior to that.
Okay, so the next court date for Ms. Gardner will be, that's August 27th, it's a Thursday. Do you want 8:30 or you want 9?
I'll defer to defense.
Judge, I would prefer 8:30.
Okay, 8:30 a.m. Final pretrial. And then we'll keep the jury selection dates and trial dates. I do plan to be in communication with the parties, with Gardner, the more that we learn from Fernandez. I'm doubling the number of jurors for Ms. Gardner's case in anticipation that there will be more knowledge about the case. So I also need Ms. Gardner's team to kind of think through some logistical things. For example, in Mr. Fernandez's case, we're bringing up 50 jurors morning, 50 jurors in the afternoon. I've doubled that number for Ms. Gardner's case, 100 in the morning, 100 in the afternoon. But I got to, with the other Mr. Fernandez's lawyers and team, that they wanted, and this is all kind of like food for thought that I want you all to think through for your positions at the final pretrial, meaning that Mr. Fernandez's team wanted to get to 70 questioning jurors. I need you all to get to a number that you believe, both sides, right? That this is a number that we want to be able to substantively question. Ms. Janako, how many jurors does this courtroom comfortably seat? How many jurors can we get into the pews? 100. So if you wanted, and you all have not been a part of the discussions, that's why I'm bringing it up now, okay? Our thought process in the Fernandez case has been get to whatever this magic number is, okay? And then we have that number of jurors fill out the questionnaires. You all will have the time to do whatever background information / thought process into your questioning. And from the questionnaires, the parties may glean that this person should not sit, that they're ripe for a cause challenge. I don't think that we should necessarily take up the seat nor the time having that person sit through, you know, a substantive analysis, and we can go through an excusal period based on questionnaires that both sides, maybe you agree. And I did share the updated questionnaire with the Gardner team, didn't I? Or no?
I don't believe you did, Your Honor.
Okay, I'll send that out. I would ask Ms. Wilk I'm going to ask her to send that to you. It'll have Mr. Fernandez's, but I haven't made the changes on it.
Sure.
And so I want you all also to look at the questionnaire from Mr. Fernandez. If there's anything else that you want on there, if you would let me know. At this point in time, actually, I can give you a copy before you go. Ms. Russell, Ms. Hathaway, do y'all have a copy of it? No. You don't? Okay. Give me one moment. Does it, Mr. Dreiser, do you have a copy? Or Mr. Hill? Or the state?
The questionnaire, no, electronically, Your Honor, not.
Do, okay.
Not a hard copy.
Judge, was it filed on core?
You've got to scan. Well, I will get you a copy of it. I apologize. I'll make the small edits that need, but I need you all to look at that and see if there's anything that you want in addition to or subtracted from the proposal. What I did do, what was a kind of a more major update, is that if and when a juror would identify that they live in the beaches, then they have more questions to answer. I added the social media handles for the potential jurors. Additionally, so that is a thought process, like if the parties agree, we would then excuse. The next thing is that right now we have a report back time. I need you all to start thinking about, and we'll learn from the Fernandez case, a report back window for the jurors to come back. And I think that was all that I need you all. But the magic number is really, so if we can seat 100 in here, okay? We could also fill the second jury box or jury boxes with jurors that listen, fill out a questionnaire, but listen, not question. And so if we do get close, because that is in the Gardner case, we're running up against a holiday. And so then to kind of start the process all over, if we run out of jurors through substantive questions, would be, in my mind, kind of a nightmare. So I think you all kind of need to be thinking about those things. So I'm putting all of that out there. And so for the final pretrial, logistics is important to the court so that we don't run out of jurors. And so right now, Fernandez is going to call back 100, the question 70. That's going to be kind of the magic number for them, questioning 70. And so Gardner needs to come up with whatever your positions may be. Okay?
Yes, Your Honor.
All right. Thank you.
Honor.
And, the last thing, I'm sorry, I forgot. If through the Fernandez process, we early on figure out that we may need more, I have 500 jurors coming. If you all want more than 500 coming back, you need to let me know sooner rather than later so the clerk's office can send additional summons.
So for Gardner, you have 500 summons going out?
No,
Or you
I have 500.
700 to get 500?
I don't know what they have some formula down there. I don't mess with that. I'm just saying we're going to bring up 500 people. If you believe that you would want more, then I need to let the clerk's office know sooner rather than later.
Yes, Your Honor.
Okay. All right. All right. Thank you. That's truly it. Okay.
Thank you.
All right. Thanks. Thank you.
Hey, Robin.
Okay. Thank you. All right. Are we?
So should I can send an SAL email saying false alarm? Okay, thanks. All right.
Ms. Nelson.
I saw her this
Ms.
morning.
Nelson. Melissa Nelson, State Attorney. I think you're off mute.
I'm sorry.
It's okay.
All right, so next up is going to be Mario. So that was Shanna, now it's going to be Mario.
I keep saying this is the last thing. On Ms. Gardner's case, and also for the state, Mr. Smith, who's running the IT for the court, is going to make Zoom available. So So if you want, and it will be in webinar form, so if you all want access to that, you need to let Mr. Smith know, okay?
Understood. Thank you,
Yes, Your Honor.
Outside of the live stream, so if you want webinar access to the Zoom, that's what's going to be running during the course of the trial, okay?
Thank you, Your Honor.
It's only going to be for kind of like in-court party. All right,
Thank you, Judge.
thanks.
All right, so as we knew, it was going to be Shanna first,
Okay.
and then Mario's coming up next.
Okay. Well, they send way more, Mr. Hathaway. They send way more than they need, but so we could say we want.
Shoot, I was hoping we could hear that. I love all this behind the scenes. Like we rarely see pre-trial hearings like this. I think Corey Richins, they were pretty transparent. They showed a lot of pre-trial hearings. A lot of cases we get, we don't get a lot of pre-trial hearings. You know, we get maybe one or two. So I am beyond excited that we get to hear all of this process. I think it's fantastic. I absolutely love it. All right, so yesterday we were covering a pretrial hearing with Mario, and you heard Judge Kite referencing, you know, what the Fernandez trial is going to be. So they want 50 jurors in the morning, 50 jurors in the afternoon, and with the hope of seating 40 so that they can do voir dire and go through the questionnaire and then weed them out from there. So for Shanna, she's suggesting 100 in the morning, 100 in the afternoon, because Mario's going first, so that's going to be in the news, right? Everybody's going to hear about it. It's going to be there. I'm sure there's still going to be, you know, enough people. They're going to be able. I'm pretty sure this is 12. I don't think it's 6, but I think it's 12. I'm not 100% sure yet. I haven't yet heard her say we need to seat, you know, 12 at the end, plus alternates. So I'm still not sure how many the final goal is that they're looking for. But I do agree with that this is pretty high profile, and especially with Mario being literally right up against, you know, he's scheduled to end on the 28th. They think they can do a final pretrial hearing for Shanna on the 27th. So they already think they'll be done by the 28th. So, you know, all the local news are going to be talking about it. Even NBC News did a coverage of this. So it's pretty big, and I think it will be bigger once we get to trial. Maybe Mario, I don't think he'll be as. Excuse me. It'll be covered, but I think Shanna might be the one that might get a little bit more attention, just because of her background with her family having online business. And being, you know, well-to-do. She's got Jose Baez, for crying out loud. You know, I mean, she's got some high-profile representation there. So I think Mario will get the coverage, but I think Shanna will probably get even more coverage. So that's why Judge wants to bump that up from 50 to 100. So it's going to be 100 jurors, potential jurors for Mario, but it's going to be 200. They're going to go through 200 potentially. I mean, they may be able to seat 70 in that first. Oh, here we go. Here comes Mario. All right, this is Mario coming in. I'm going to go grab some water before he starts. Seashell, yes. It will be Judge Lyndon Kite. Judge Kite will be for all the pre-trials. This is her trial. So she's going to be doing both trials. So yes. Jenny Lynn, how are you? Good to see you. And Jenny G coming in. How are you doing? Good morning and happy Friday to you. There was a whole hearing about that they severed them. Let me see if I can find a concise way why they did that. Let me see. See if I can find. I want to think that was the one with Jose. I'm not quite sure. Oh yeah, and Mario's verdict will not remain sealed until the outcome. So it'll be revealed once a jury reaches it. So they were asking to seal the outcome. Let me see. So it's just saying that she severed it. I'm trying to figure out why she severed it. Oh, it was because Henry Tenon withdrew his guilty plea. I guess that's why. Okay. So it was Henry Tenon. So if Henry Tenon, who is the alleged trigger man, if he had continued with his guilty plea, they would have gone together. But because he withdrew his guilty plea, both parties agreed they should face separate trials. We did watch that hearing. Maybe we can revisit that at some point too, or I'll rewatch it to see what their actual logic was. All right. So, Assistant State Attorney Alan Mizrahi argued that the original plan was to try Gardner and Fernandez together was logical because Tenon was a testifying witness in both. Okay, I get that. Without him, it becomes less of a priority for the state to keep them together, pointing out that shuffling the separate juries in and out of the courtroom complicates the trial. All right, this is not the case or a situation where we're going to be able to shuffle a jury out for a witness or shuffle a jury out for part of our opening. The core of the Gardner case is inadmissible. In the Fernandez case, we're talking about at least 6 witnesses, if not more. So that's why. And we saw that in that. Was it DTE, the Detroit? What was it? Electric company. Remember that, where they came in and they robbed that one guy and they took his life. They had 2 separate juries for those 2. So that's why. It's because Henry Tenon pled guilty. He's going to trial in 2027, and they would have been shuffling jurors out for at least 6 witnesses. So that makes sense. Let's see. Susan, thank you for the 5 Trial TV Live gifted memberships. Happy Cappy got one. Neil got one. Awesome. I love it when people are in chat and they get one. Is RV ready with us? Kitty Laughin, are you with us? And Betty? Bet Noir. Thank you for and thank you, Debbie, for the, stay hydrated. I got my water. I got my water in my mug. Stay hydrated, guys. I love it when people get memberships in the, there you are, Happy Cappy. Happy Cappy. Granny Debbie. You guys have such fun handles. I love saying your handles. Granny, is DP on? No, they took it off. They removed it. Let me see why they removed it. Because it was on the table. They may not have had I think sometimes you need really aggravating factors. Let's see, maybe that's why. Okay, judge orders private hearing on Shanna Gardner's motion. Okay, that's something else. Okay, that's what we just heard. Okay, what about... That was Kirsten. Kirsten Bridegan. Let's see. All right, well, here's a timeline. This is great. More than 4 years ago, Jared dropped his then 9-year-old twin children off at the home of Shanna Gardner after a date night with their dad. Okay, he left Gardner's Jacksonville Beach home on February 16th, 2022 with his 2-year-old daughter strapped in the car seat in the back of his dark-colored SUV. They were headed back to St. Augustine, which is a little bit south of Jacksonville. But the 33-year-old Microsoft executive never made it home. Following his normal route through the sanctuary neighborhood, Bridegan suddenly had to stop in the area of Jacksonville Drive, American Avenue, and Sanctuary Boulevard. A tire was in the road. When Bridegan stepped out of his SUV, he was ambushed. At least one missed his daughter by mere inches in her car seat. So that's why they wanted the child ABU, you know the word. That's why they wanted that. They have since dropped that. So, Bridegan was left lying in the street next to his SUV with the door wide open. None of the 911 callers mentioned seeing the person or a vehicle leaving the scene. So this was all part of a deletion to hire plot set in motion by Gardner and her new husband Mario. Conspiracy that began in November of 2021, according to court documents. According to detectives, Gardner was tired of sharing custody of her 2 children with Bridegan. Fernandez, she knew, could take care of him because of his military background, Gardner told a friend. At least that's what the friend told investigators as she detailed the strained marriage between Gardner and Fernandez and the contentious ongoing custody battle between Gardner and Bridegan. Investigators say that's exactly what Fernandez did, hiring Henry Tenon, a tenant at one of the properties, to take out Bridegan. In his initial interview with police in July of 2024, Tenon told investigators that he had been renting a home from Fernandez in Jacksonville's Biltmore neighborhood for several years. Tenon's original court record said he became involved in the conspiracy on January 4th of 2022, just over 1 month before Bridegan was taken out. Investigators said when Tenon was arrested on an unrelated felony driving charge in August of 2022, they questioned him about Bridegan's deletion and a Ford F-150 truck that they had been searching for since then. Tenon was later arrested in Bridegan's murder, and investigators said the single link between Tenon and Bridegan was Fernandez. Sorry about that. Looks like they might be coming to order. So if state prosecutors initially said they'd be seeking the DP, but they have since taken it off the table. It doesn't say why. All right. All right, here we go.
Stage is ready.
Yes, Your Honor. The defense, on behalf of Mr. Fernandez, Jesse Dreiser, and I represent Mr. Fernandez, along with Mr. Hill is present, Ms. Day is present, and my client, Mr. Fernandez, is sitting right behind me.
And I think I saw Mr. Tassoni on Zoom.
Okay.
Good morning, Your Honor.
Good morning.
Good morning, Mr. Tassoni.
All right.
Little housekeeping. The defense would make an oral motion to have the court order juror anonymity and protection.
And does the state join in that motion as well?
State joins, Your Honor.
Okay. So in the upcoming jury selection, the court, obviously by previous order, has determined that 2 phases is necessary. The court will enter an order on juror anonymity and also protection in pursuant to Rule 2.420, taking that rule completely to heart. The prospective jurors that are excused will the court records will only be confidential for the time period that is necessary in order to select the jury. And then once that jury is seated, their information will become available to the public records laws. Then the seated jury and the alternate jurors will also be protected, obviously, for the end of the trial proceedings. And so I'm entering that order today, so I'd ask the clerk's office to file that. I believe that we've talked about, at least at sidebar, some administrative matters, and so I'm ready to go on to substance if you all are.
State's ready.
Defense is ready.
There are a couple of motions that have been unresolved, and that, you know, I've been helped because the docket is deep. So I'm going to bring up some blasts from the past. There was a defendant's second motion for bill of particulars, and I think that...
Yeah, that's going to be a star feature of today's issue.
And then there was, on March 30th, 2026, docket line 570, there was the defendant's motion to suppress the cell phone records.
That one the defense withdraws.
Okay. Thank you. I know that we have mentioned it on prior dates, but there was no resolution by the court on docket line 597, filed on April 17, 2026, the defendant's motion to adopt Gardner's motion to exclude minor child.
I believe that was resolved by way of a stipulation of BB.
We filed a written stipulation.
Okay. Thank you. Could you all find that for me? Do you know what docket line the stipulation's on?
Yes, Your Honor, one moment.
Abandon that one.
Judge Weaver, I believe it's moot because of the state's notice of which counts we're proceeding on. I did provide Mr. Dreiser with a written stipulation regarding BB and the admission of a video. I'm just waiting for them to sign it, and then we will file it.
And it wasn't not signed
Right.
for any other reason than I thought I signed it already.
Oh, okay.
So.
Well, I'll just put, it's fine. I'll just put by stipulation of the parties moot.
Yes.
Okay. All right, and now I think that based on that, going back to the docket line 516, I think that we're now up to date on what's pending. So which one do you all want to take up first?
I think Mr. Mizrahi and I agree we'll take up the defendant's first motion in limine to prevent the introduction of hearsay and impermissible testimony, if that's okay with the court.
Yes. Okay, I'm ready.
So, Your Honor, just let me sort of outline what this motion is as well as the other motion, because they're very much blended, okay? So there's two anticipated statements that we believe the state is going to try to get in. For the purposes, before I get to my argument on the very first motion, they're both statements that we believe are covered by the marital privilege. The state's theory of why they should come in is the marital privilege doesn't apply, at least to the state's first motion in limine. I'm not sure their theory on the second, but it comes in on the state's first motion in limine under a co-conspirator statement. So the reason I bring this up is, number one, many of the marital privilege arguments will go to motion in limine number one, as well as motion in limine number two. In addition, it's our argument, and I do think the state actually agrees with this, that if you find that the statement between, in defense motion in limine number one is marital, we don't have to go to whether it's a co-conspirator statement. It wouldn't come in because it would be marital. So I bring that, there could be some efficiency here to sort of decide whether we need to go into the second argument. If you find it's marital, there's no conspiracy argument to be made, and it would save quite a bit of argument as to those bill of particulars, as well as the complexity of conspiracy law. So I'll let you decide where you're at as terms of marital privilege. But marital privilege in the state of Florida under 9504, it reads, a spouse has a privilege during and after the marital relationship to refuse to disclose and to prevent another from disclosing communications which were intended to be made in confidence between the spouses while they were husband and wife. The privilege may be claimed by either spouse or by the guardian or conservator of a spouse. The authority of a spouse or a guardian or conservator of a spouse to claim the privilege is presumed in the absence or contrary of evidence. Then the statute goes on to very clearly say that there is no privilege under this section under A, B, and C. But I'm going to focus your attention on B because that's what the state is attempting to break the marital privilege. And it says, in a criminal proceeding in which one spouse is charged with a crime committed at any time against the person or property of the other spouse, or, and what the state's relying on, the person or property of either child of either. And that's what the court has to specifically note in this argument. If there's any argument that it was anticipated that by these statements that the state's trying to elicit, that they even would go to the fact that child abuse was anticipated in this case, it would be against BB, who is a child of Jared Bridegan and Kirsten Bridegan. BB is not a child of Mario Fernandez. BB is not a child of Shanna Gardner. The statute is explicitly clear as to that point. I will read to you directly from Earnhardt as the abrogation of child abuse statute, as well as the concept of the statutory construction that it has to be a child of either, is addressed. In addition, there is no marital privilege if the crime charged is against the child of either spouse. Policy reasons require that the privilege not be recognized. The policy is reflected in section 39204, which I will represent to you as the abrogation of child abuse, of Florida statutes, which denies the marital privilege in litigation arising out of child abuse cases if the crime has been committed by one spouse against the other spouse, or the other spouse, or a child of one of the spouses. There is no benefit to the marital relations by suppressing the testimony. There is a public policy to not allowing, in Florida, as you know, one spouse can raise the privilege against the other spouse. There's a public policy reason that you can't prevent your own husband or wife from not talking about the abuse of the children of the marriage. There's no public policy that would allow, and there is not a single case that I can find in the state of Florida that addresses the marital privilege being broken because it's a child of another. And if we look to the Williams case, do you have a copy of that, Your Honor?
Give me one moment. I do. Okay. I'm ready.
on page 2, we find that Ms. Williams' statement regarding Appellate's street name was not protected by the husband-wife privilege because that information was known generally in the community. However, considering the record before us, we must conclude that the trial court erroneously permitted Ms. Williams to testify about Appellant's statement that he needed money to pay his attorney. A communication between a husband and wife is presumed confidential unless there is evidence to the contrary. At trial, neither appellant nor his wife testified whether they meant their communication to be private or public. Likewise, there was no testimony that the statement was made in the presence of a third party or that the appellant instructed his wife to disclose this information to another person. Without this information, it is impossible to determine whether that privilege had been waived. As such, the state did not overcome the presumption that the statement is covered by the husband-wife privilege. Therefore, it was error for the trial court to admit Ms. Williams' statements over defense counsel's objections. And the reason that's so important is, I suppose the state could make an argument that the statement that they're trying to elicit, which has never been clearly outlined, but we assumed that Shanna Gardner tells her friend, Kim Jensen, about a conversation that Mario had with his wife, Shanna Gardner. So it's what Mario Fernandez supposedly said to his wife, not in the presence of a third party, no evidence that was instructed to be shared, in confidence with his wife, and then his wife tells the friend. And in Florida, of course, one party can elicit the privilege, and unless the state has evidence, independent evidence to prove that Mr. Fernandez did not intend for that statement to be confidential, it's a marital statement. Of course, the state also cites the Hill case. And do you have a copy of that, Your Honor?
I do.
Okay. So the brief facts of the Hill case are that a husband and wife have a conversation at some point about whether or not there was any issues regarding the functionality of the cruise control on the car. And in this particular case, the wife, in an extreme tragic, left an appointment. She had her child in the car, and she had a neighbor's child in the car. And her child was killed. And in the Hill case, they go on to say that the abrogation of child abuse statute did apply. And of course, in that particular case, the child of the husband and wife was killed. And what I would point out specifically is that on page 4, when they go through the privilege, they specifically say in B, in a criminal proceeding in which one spouse is charged with a crime committed against the other person or property of the other spouse, or the person or property of a child of either, emphasis added. So this case, clearly the court had the right because they believe that a child of theirs passed. And then the court goes on to a whole nother analysis of the psycho-patient privilege. The state, in this case, has provided State v. Jett, which is the psycho-patient privilege, and it's just inapplicable. Every privilege in the state of Florida has its own statutory construction. There are exceptions for the attorney-client privilege, there are exceptions for the psycho-patient privilege, and there are exceptions for the marital privilege. And there are dozens, if not hundreds, of cases that talk about how the marital privilege is one of, if not the most, protected privileges of all for many public policy reasons. In fact, they all say that if the court were to deny a marital privilege, you can take a writ of cert prior to trial, because in fact, you cannot stuff the cat back into the bag. That's what the case law says. It is so imperative that the communications between a husband and wife are never breached unless there is clear authority from the court that it be breached, that you can take a pretrial writ of cert. I did find, and I sent this morning, the Schwartz v. State of Florida case. Do you have that, Your Honor?
I do.
I went and I spent more time than I'd care to admit on my case law research trying to find one case where the abrogation of child abuse was used and it was not a child of either. I didn't think I'd find one because it's clear in the statutory construction that it says a child of either. But I went as far as I could to find one. And I found a 2025 case, Schwartz v. Florida, 413 Southern 3rd. And in this particular case, it was a husband and wife who presumably had some communications, and then there was a Ring doorbell or some kind of surveillance. And the court ruled that surveillance or observations between a husband and wife are not privileged. And I don't dispute that. I've known that for years. It's only the communications. And in this case, the child that was abused was not a child of the husband and wife. It was a niece of the husband. But in looking to try to find a case, what I found instructive was if you go to the facts and you go to page 5 of 7, Your Honor, where the court rules in favor of the state and says it's not privileged. It was an observation, it was a Ring doorbell camera, and that matter is not privileged. But if you go to the first paragraph at the top, where I do think is instructive, is the last sentence. The trial court disagreed, ruling the footage could come into evidence, but directing the state to present a, quote, truncated, end quote, version to exclude any protected marital communications. If the state's premise is true, and that it can be a child or a niece or a child of anybody, any other couple, they would have never wrote that. They would have said it was an abrogation of child support. This niece was clearly accused of child abuse. It was child molestation. And the court ruled that the marital privilege still remained intact and instructed the state to have a truncated version to not invade the marital privilege. So although I don't believe this case is directly on point, it does give us just instruction that when there's a child abuse case and there's a niece, not a child, the marital privilege is still, in fact, intact. I also would, if you look to the actual statement that the state is trying to elicit, Your Honor, let me find that. Something to the effect of, did Shanna ever tell you that she told Mario that she wanted him to act upon that promise? Jensen, Mario told her, if you don't, I can't remember exactly when the conversation was, but he told her, if you don't want this to happen, you'd better tell me now. And she said, do not. I choose you. I don't want this. I choose you. Ms. Rahi, she told you that she told him that? Yes. Ms. Rahi, but you don't know when that was in this whole timeline? Jensen, I think it was in Hawaii the last time they went, but she said, I don't want this. I don't want any part of this. I don't want you to do anything. And I'm going to read from more of that if we get into the conspiracy argument, because she later goes on to say, I really don't know when it was. It could have been in another trip. But for the purposes of that statement that they're trying to get in, what part of that statement, given that there's absolutely no agreement in there, would give anyone rise that that would lead to child abuse? Ms. Jensen never clarifies, and she's testified before this court, and she's spoken in front of the grand jury, and she's spoken at bond hearings. She never clarifies what that is. She doesn't say whether it's to beat him up, whether it's to murder him, whether it's to make sure that he lives a rotten life. There is no ever explanation, and even more so, the conversation she reports is that Shanna Gardner says, no, don't do that. I don't want that to happen. I choose you. So before we even, I'm not conceding that it is the abrogation of child abuse statute even applies to this case, because it's not foreseeable from that particular statement that this was going to lead to child abuse. If the court's not persuaded by that, BB, the child who and I don't mean to say this disrespectfully, supposedly was abused in this case. The state dropped the child abuse count. The child was very young. We've deposed all the witnesses. I don't agree that BB had any actual child abuse physically or mentally from that. But regardless, BB, and more importantly, BB is not a child of Mario Fernandez and Shanna Gardner, and therefore there is no vehicle in which the state can get that statement in. I would think that it would be most efficient for me to move to my second motion in limine.
Okay.
And then argue the same marital privilege, and then see where you're at after the state argues, and then we can go back to whether, if you say, I don't believe it is marital, if that's the conclusion you come to, then we would argue whether it's a co-conspirator statement or not.
Okay.
Okay?
You can move on.
All right. My second motion in limine is in regard to a motion in limine to prevent the introduction of impermissible testimony, which is statements that AB, who is a child of Shanna Gardner and Jared Bridegan, says in a recorded interview when she is interviewed by a police department, I think in North Carolina. They ask her about some new information. And this is what she says, Judge. Ms. Stifler has told me she's going to introduce the actual 4-minute clip on a CD.
She's Ms. Stifler.
Do you want to put the video in?
I apologize, Your Honor. I thought we were handling the first one. I provided a video clip to Mr. Hathaway upon stipulation, and I think no objection from defense. It's a roughly 3.5-minute video of a police interview conducted of AB by New Hanover Police Department in North Carolina. Timestamp 25 minutes, 25 seconds to 29 minutes.
And
so this is being published on the media. Do you want to?
How I would present my argument is I transcribed it, not through a transcription agency, but Ms. Day transcribed it word for word. I've shown it to Ms. Stifler. I think she agrees that it's accurate. We can still put it in, but I was just going to read exactly what it says.
Okay. Is that acceptable to the state?
Yes.
Okay.
So, just to give some context, Abby's in a child protective type room. A detective's in the room. She's on a couch, and Abby says, in response to some question like, "Is there anything that you would like to tell me?" Some generic question. At my house in Florida, it was a 2-story house, and I was on the 2nd floor, and I had a master bedroom, so I covered like the whole house pretty much. And you could hear what they would talk about. And they would just be like, quote, "Oh, he'd be better off dead," or something like that. The detective asked who was they, and Abby said, Shanna and Mario. When asked when she heard these jokes, Abby said, "It was like for a long period of time. So they did it like months. It was kind of off and on when they would talk about it, but they did it like before he died, and then they didn't talk about it that much during like the 2 months after, but after they kind of talked about it." When asked what else Shanna and Mario said, Abby said, "They just said like, he's a horrible person. Like, I wouldn't feel bad if he like died. Like, he has a right to die. He doesn't deserve to be in this world. That's what I remember." The detective asked if they ever talked face to face with Abby about stuff like this, and she said no. Your Honor.
Judge, the reason I wanted the court to watch it, I think there's just the context and how she says things matters a little bit. So just to add, at least from my notes.
Well, you can play it. I mean.
I don't have an objection to it being played. I don't have an objection to the court taking it into chambers and listening to it.
That's fine with the state.
I have no objection. My notes, I believe, are accurate, but admit it, play it in chambers. It doesn't change my
If you want to play it, I'm just pointing out, last time AB was an issue, you asked for non-publish of the video. I'm happy to hear it if you want and see it, but if it's published on the cart, they would have to kill the videos.
It's a CPT interview, so I do believe there are some protections for public records as exemptions, which is why I wanted to provide a copy to the court to review.
Do you want me to do it in chambers? I can. Okay.
Yes, ma'am.
Mr. Dreiser said you were going to play it, so I was just pointing it out. Okay.
You want to do that in chambers now or later?
I can go back now. And
it's only 4 minutes.
I think we could do it later. Let's just get through the arguments and then the court can.
Sure enough.
My thought process.
Okay. So, Judge, again, reading directly from Earhart's, however, when there is a reasonable expectation of privacy, and if the spouses intended their communications that their communications are privileged, the privilege applies despite the fact that communications are overheard. If an unknown third person listens through a closed door, and when it is not reasonably apparent to either the husband or the wife that the third party is present, the privilege is not destroyed. When you watch the video and when you hear the statements that I made, AB is clearly talking about being in her master bedroom upstairs. She has like what she describes as a very big master bedroom. And Mario, Mr. Fernandez, and Ms. Gardner are downstairs. And then luckily for us, the defendant specifically asks, did they ever speak with you face to face about stuff like that? And she says no. So again, you go back to the case of Williams, where it talks about privileges, it talks about reasonable expectations of privacy, and it instructs the court that the state has to prove by independent evidence that Mario, Mr. Fernandez, and Ms. Gardner would not have intended that conversation to be confidential. And there is no way from the clip that you're going to listen to in chambers that there is proof that it was done in front of her or they knew. And she starts out the whole premise with, I would be upstairs in my room and they would be downstairs. It's not even a door, as example like Earhart uses. It's a whole floor of a house. So again, I do not believe the marital privilege is broken. I do not believe AB should be able to testify to conversations that you have no independent evidence were meant to not be privileged between a husband and a wife. And we would ask for you to exclude all of the statements that AB allegedly heard by eavesdropping between a conversation between a husband and a wife. If I just have one moment, I think I can turn it over as to those two issues to the state.
Okay.
Thank you, Woody, for your help.
All right. Thank you.
Are you done? Say, give him a minute.
Oh, okay.
I'm sorry. Yes, Your Honor. I'll turn it over to the state.
Thank you. Mr. Mizrahi.
Thank you, Your Honor. May it please the court. Defense counsel is erroneously stating the state's theory on this, and I'm going to take the court step by step about why there is a clear piercing of the husband-wife privilege in this case. The first idea is that Mr. Dreiser indicates that we're only going on the theory of BB being in the vehicle when her father was shot, which the state had charged as child abuse, and that certainly is one theory. But frankly, the stronger theory the state is going on is that the motive behind this killing, and we will present this with witness after witness after witness, that the motive behind this killing was to eliminate Jared Bridegan's custody of his 2 children, the children of Shanna Gardner. That is why this murder was committed. And obviously, this is a hearsay statement between husband and wife, one of which their children was the goal of why the victim was eliminated. The child abuse statute under 827.03, which I know the court is familiar with, defines child abuse as an intentional act that could reasonably be expected to result in physical or mental injury to a child. There is no other interpretation of that statute than the murdering of the father of 2 minor children would not reasonably be expected to cause mental injury to the child. It is just that simple. And if that is true, the court doesn't need to make any more findings about whether or not the husband-wife privilege is pierced. But additionally, the state provided, and I appreciate Mr. Dreiser providing the court with the case law, but he neglected to mention the Supreme Court case of Florida that the state provided, Your Honor, State v. Jet, 626 Southern 2nd, 691 is a 1993 case that specifically and unequivocally states, we answer the rephrased question, which is whether Chapter 39, proceedings relating to children, abrogates the privileged communications involving child abuse, whether it only applies if it's one of the caregivers. And it says, we answer, I'll read the question, the certified question, and then the answer. Does Florida statutes 90, and it gives the year, waive the psychotherapist client privilege only as to proceedings brought under the Florida child abuse or neglect statutes? Under 39 and 827, we have jurisdiction. We answer the rephrased question in the negative. We find that the waiver of the privilege in this context reaches to any proceeding involving an action or offense that meets the statutory definition of child abuse or neglect, whether or not the child abuse or neglect is a necessary element of that action or offense. Chapter 39.204 does not in any way, shape, or form indicate it has to be a child of one of the others. It doesn't say that. It says the abrogation of privileged communications relates to, and I'll read it to the exclusion of confidential communications shall not apply to any communication involving the perpetrator or alleged perpetrator in any situation. Doesn't restrict it to the children of the perpetrators. In any situation involving known or suspected child abuse, abandonment, or neglect. So, Chapter 39, in conjunction with the husband-wife privilege under Chapter 90, clearly sets an exception to cases involving suspected child abuse. And that goes as well to the second motion in limine with regard to AB and the potential eavesdropping. The only comment I would make for that is the state would request a proffer of AB with regard to the issue of eavesdropping if the court does not find what the state is arguing, the husband-wife privilege does not apply to any communications between the co-defendants about the murder of Jared Bridegan, since the goal of that murder was to eliminate the child custody of the victim. And we'd like just, if the court didn't find that, we'd want to proffer that. I just mentioned that. So, but
At what point in time?
When we present it. It wouldn't be an opening or anything like that. I would also, just interestingly enough, the court's worried about our ability to prove child abuse. I would point the court to the Hill case that the defense mentioned, which is Hill v. State, and it's 846 Southern 2nd, 1208. It's 2003 5th DCA case. And the court was a little bit troubled by the concept that while this child abuse, or in this particular case it was a child neglect, seems a little far-fetched. I want to read to Your Honor what the court said. It says, although we have found no case in which the defendant has been convicted of the crime of child neglect because of his or her reckless driving of the vehicle which resulted in injury to a child, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason the charge could not be proven in theory, because of the clear statutory language in both 39.204 and section 827.03, which is the child abuse statute. We agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect. And so we have statements about he doesn't deserve to live, I'm going to kill him, all relate to the elimination of the parent of these two children. Elimination of a custodial parent of a minor child can reasonably be expected to result in the mental injury to those children. We don't have to prove the child abuse according to very clear case law. It doesn't have to be charged, nor do we have to prove the child abuse beyond a reasonable doubt. But the statements have to relate to suspected, remember chapter 39 says suspected child abuse or neglect. And so for those reasons, the husband and wife privilege does not apply to statements made by co-conspirators about the murder of Jared Bridegan.
So what is the state's position as to the first motion in limine to Ms. Jensen?
Well,
and Mr. Dreiser's argument that those statements to that point, like they're vague, they don't say one way or another.
He's referring to one statement. I think I understand what the court's question is. Well, the state is not just introducing that statement. We will be introducing a series of statements that set forth the concept that Shanna Gardner was trying to hire someone, find someone, ask someone to kill her husband because of child custody issues. I anticipate that the witness will testify to that. Although she will qualify it by saying, at least if she's allowed to say what Shanna Gardner was thinking, which is the subject to another motion in limine, I do believe that Jensen can testify as to what she believed and what she thought. She thought these were all just jokes. But the evidence is an offer was made by Shanna Gardner saying, can you find someone to help me? Jensen accepted that offer by seeking out other people to kill Jared Bridegan. And then the conversation was all about the custody of the children. The elimination of Jared Bridegan was not for any other reason other than the fact she couldn't tolerate this man supervising her children. Her children would go to him, they had joint custody, so every week they'd be gone for 6 or 7 days, and they would have 1 day of visitation, and they would go back and forth and back and forth. We are going to be able to establish that and a timeline continuum that was never broken, under which Shanna Gardner told Kim Jensen, I can't stand my ex-husband, I don't want him to have custody of my children anymore. That's the whole basis of the whole child custody issues in the St. Johns County case, is it was all about child custody. Mario came to the picture, and Fernandez was going to solve this child custody issue. And even Jensen will testify to that he said he could solve the child custody issue. And then Shanna Gardner repeatedly told Kim Jensen multiple different situations under which Mario indicated to Shanna Gardner how Mario Fernandez was going to solve the Jared Bridegan problem. That he could almost touch him, he had people that were out looking for him, he knew people that could do things and help her. They're all relatively vague statements, but remember, they don't have to be direct. If the point is to take care of the child custody issue, and he says, I'm going to solve that, and then as Mr. Dreiser indicates in the last statement, which is a week before Jared Bridegan is murdered because it's during the Hawaii trip, that Kim Jensen says, at that time, Mario Fernandez was unequivocal saying, I am finally going to make this happen. You have to tell me not to. And then Jensen's testimony is that Shanna Gardner says, Mario told me he was going to kill the victim, take care of it, get rid of him, whatever language you want to use, and I told him not to. But that is for the weight of the jury to decide whether or not those statements were really made. The statement from Mario to Shanna Gardner should be pierced because he says, I want to kill the victim, and it's for child custody. Does that answer the court's question? We have years of these statements.
Okay, but what's been identified for the court to rule on is very short, it's succinct, and so the defense is not bringing objection to what Mr. Mizrahi is outlining?
Yeah, I'm bringing enormous amount of objection. We now have circulated into the statement of bill of particulars, and it is quite frankly unbelievable to me that the state is now relying on the years of Shanna Gardner's and Kim Jensen's messaging to each other in Mr. Fernandez's case. It'll take me a minute to get prepared to argue how absurd that is.
Okay, well, why don't I take a break and I'm going to look at AB's video. But
I'm ready now.
I can't rule on something that's like what I have sitting before me is not even 2 pages.
Well, certainly we can submit the sworn testimony of Kim Jensen, but until,
Right, but what I'm saying is, so what was before me is a statement. Mr. Dreiser has made a succinct argument saying, and that's why I asked the question, is because the state's argument that Hill applies to the statements of Jensen, saying that the statements go to that, the substance of this statement, Mr. Dreiser has argued vague, doesn't go to any sort of child abuse, and then now the state is bringing in other statements that aren't being objected to. I was just trying to clarify.
Maybe I did important. The statement to pierce the husband-wife privilege doesn't have to, in the statement itself, talk about an act of child abuse or neglect. The statement, they said the Schwartz case had to do with cruise control. So the statement itself doesn't have anything necessarily to do with the underlying crime. It's our duty and our responsibility, whatever our burden, to be able to establish that that was the underlying purpose of the statement. So the statement, I'm going to take care of Jared, doesn't say anything about the children. We are going to establish via other evidence, specifically the defendant's own words, that he was going to eliminate the victim specifically to eliminate his child custody rights over the children. This was all about child custody. So we have
And so what you were proffering to the court would not be statements related to the marital privilege. You're saying that those statements are kind of outside of what is being objected to within this motion.
For us to be able to establish that this was not marital privilege, we will present other evidence, like the defendant's own words after the fact to a third party saying, I did this for child custody reasons.
Where is that statement in discovery?
Excuse me.
Okay.
I'm not arguing right now. I'm paraphrasing, obviously I'm paraphrasing, but we do have evidence of that.
Well, I'm gonna take a break, okay? Let me see AB's video and you all talk, okay? Court's in recess.
Got a little spicy there. Got a little spicy. So Judge Kite's going to take a break. It's a 4-minute video. Apparently, it's this a video of the daughter overhearing Mario and Shanna talking about what happened, taking out Jared. Whatever it is. So they're basically talking about a husband-wife privilege here. This is what this is all about. And then also BB, which is the little girl that was in, the daughter of Jared, not of Shanna, but of Kirsten. She was in the car when this happened. And apparently it missed her just by a couple inches, I guess. So this could have been a lot worse. All right, so this is a 4-minute video, so that'll probably get us close to 12. Remember, Judge Kite has a sentencing at 1, so they can't go they can't go too much longer. Maybe another half hour, 45 minutes, I guess, is about as far as they can get. So, and we have a surprise for you that does have to do with Corey Richins. So she is in court, and we will be showing that. It'll be a little bit later today. We'll show that a little bit later today. So something to look forward to. After this wraps up here, we will take a break. I'm not sure how long Corey will last, but depending on how long she lasts will depend on when we come back up online. So while Judge Kite reviews this 4-minute video, and they talked about that Kim Jenkins. I don't know if you guys have seen that. That's been circulating. Her interview with law enforcement is pretty good. We asked the original creator if we could use that, and we haven't heard back from them. But I would like to show that interview. It's pretty intense, pretty damning. She definitely talks about Shanna talking all about this, and she talks about Jared and the upbringing. She talks about Shanna's upbringing. Latter-day Saints. She was Mormon. And yeah, it's an interesting interview. So far, okay. So Jose Baez is representing Shanna. He was there via Zoom earlier. So that was earlier today. That was the supposed to start at 10. It didn't start until like 10:30 or quarter till. And that one was basically just kind of doing some housekeeping, going over jury selection, how many jurors they're going to select. They want 100. Whereas Shanna was only going to have, I'm sorry, they want 200. Yeah, they want 200. So Mario wanted 50 and 50, or they settled on 50 in the morning, 50 in the afternoon, and then they would seat 70, and then they would try and figure out who to pick from there. Judge Kite's saying, well, because Mario's going first, there's definitely going to be coverage on this. People in the jury pool are going to, just in passing, hear about this trial. So that's why they want a larger pool for Shanna. And her jury selection starts a little bit later. So Mario is on the 10th, starts on the 10th jury selection. Shanna's starts on the 31st of August. Okay, so that was Shanna's, again, just some housekeeping. She was basically just housekeeping and kind of figuring out what number of the jurors, how many prospective jurors to pick. And now for Mario, this is more about they want to suppress. Actually, the defense withdrew their motion to suppress cell phone records. And then now it's all about this minor child, BB. They both had stipulated for her not to testify. But there is this interview that they're kind of squabbling about now. And defense is saying there's two statements the state will bring in, and both are covering marital privilege. So the defense is saying any statement that's overheard via eavesdropping should be covered. BB is not the child of Mario or Shanna, and the statute is explicitly clear about that regarding child, AB, the word. So she was in the car. So that's that's Jared and Kirsten's daughter who was in the car. And the state did drop those charges. They did drop those charges for Mario. I did not hear that they dropped it for Shanna, I should say. I keep saying Shanna. So all right. Did I spoil the surprise? I don't think I did. $10.14. You need a convoy or escort, a person or inmate. Looks like a 10 code to me. Gotcha. Sherry, defense absolutely doesn't want it in. Of course they don't. I hope the judge favors the state. Look how busy the Florida seal is. It's a crime. I was wondering why then. I'm just scrolling back. It should be a gator eating a man who has no high school diploma. Ed, that's not very nice. Megataz Mom says Shanna moved the kids to Washington immediately after this happened to keep them away from Jared's family. They own Stampin' Up. Yes, they do. Oh, maybe we could show. Her mom and her sister. Well, her mom and aunt. It was the two sisters started the company, right? And they used to be on their website. They took themselves off the website because we were doing deep dives. We've done quite a few, and they used to be under the About Us. And they are no longer on the About Us. Yeah, they took themselves off their About Us. I was going to show you them. I don't know if I took any screenshots. See if I took any screenshots. I don't think I did. I should have taken some screenshots. So her mom and her aunt used to be on Stampin' Up, and they took themselves off of the About Us because they would say when they created it. Well, they began in 1988. With a belief that still guides us today, inspire people to create and share meaningful experiences with others. So they work North America, South Pacific, and Europe. So Stampin' Up. It's basically like crafts, right? Is that pretty much what it is? Shop all products. So it's craft class, birthday paper, days kits, gold Stampin' hot foil rolls, gilded gallery. So I guess you can make like cards, you can make posters. It's just all a bunch of craft, kind of fun, crafty stuff. There's alphabets and numbers, hot foil, dies, butterfly flight decorative masks. You can do masks. I mean, it's a cool thing, cool place. Cool idea. Some black ribbon. We used to have a Michael's where Aaron and I used to live. It's kind of the same, where it's, if you are into crafts and you want to, make things, it's kind of like that, but this is online. So, stickers, do they do stickers? Do they do stickers too? Barry says, I got a ramped up pyramid scheme and a little vibe from them. Stamped up, ramped up. Yes, it's like, scrapbooking. It's ow, why? What? Why? It's like, it's a craft like scrapbooking and cards, exactly. Megataz Mom says they bought out close to my heart as those owners wanted out. Okay, stop. Why are you biting me? Stop it. Stop it. Here I am petting her and she's biting me. Why are you biting me? Here's a little Super Ball. Yes. Why are you biting me? Why? Oh, it's a go girl. It's a go girl. Little Super Ball. Okay. Yes, Super Ball. You still have Michael's? Yeah. I didn't know if they went out of business or not. Sherry says, your friend sent me a whole box of stamps so we could get into it, but it's still an unopened box. I'm too busy watching your trials. Nice. Avon, Mary Kay, even Amway, I can live with, even with iRoll, but I never associate having it. A neighborhood scrapbook rep. Do they have it really? Is that how it is? They have representatives, really? Hellrider, how are you? Yes, Debbie. She's well now with the heat and no AC. She's been not eating as much. She eats just in the morning, and that's it. It's been tough on little Super Ball. Everybody else is fine eating, but Super Ball's, she's got a sensitive little system. Sensitive little Super Ball. Dina, how are you? Welcome in. Jenny Lynn says, I only feel teeth at 4 a.m. when Benedict nibbles my nostrils to let me know he's ready to eat. That's interesting. Super Bowl silently staring from the back until you hit the like. Yes. Green Eye Cat, Joanne's closet. Oh, Joanne's closed most of their stores over this past year. I remember Joanne's. I do remember Joanne's. Hellrider, you're good? Just out on the old bike, loving the weather? Awesome. Yeah, enjoy it. Enjoy it while it's out there. Hobby Lobby I've heard of. I have heard of Hobby Lobby before. What's MLM? MLM. What's that, like marketing level something? What is that? Multi-level marketing. So the pyramid scheme, I gotcha. Multi-level marketing. Okay. Multi-level marketing. Grampy, yes, Grampy. Your favorite girl is right here. Your little therapist. Debbie had a Joann's too. Who went out of business. I kind of remember Joann's. Carol, I do those diamond paintings when you're bored, but they are not something I would actually put on my walls, so they're just out in a box. So they're just out in a box afterwards. Yes, multi-level marketing. Is Super Ball the CEO? Yes, she's my paralegal. She's my paralegal. Megataz Mom says, it's overpriced. I'd rather buy directly from the manufacturer or at a craft store or the craft stores. Oh, Michaels are still around. I think who said that? Michaels are. Oh, there it is. Shirley. Yeah, you still have Michaels in Montreal. Lots of Michaels in Montreal. All right. Sherry says, Super Ball makes me smile and gives me so much joy to see her. Such a sweet girl. Yeah, she's just right here. She's getting all kinds of love. Dragonflies, you have Michael's in Charlottesville. Michael's online prices are lower than at the store. Well, that's good that they're still around. I used to, we went in there quite a few times. I remember Michael's. This was down in Palm Beach area. Boynton Beach. That's when we used to go to. Barry, I get a lot of craft stuff when I do craft stuff, but our Ocean State job a lot. Oh, from our Ocean State job a lot. Gotcha. Kaylee, you just got dumped by YouTube. Yeah, that's somebody else said they were having problems with that too. Somebody yesterday, I think, was saying that they just got bumped out too. I don't know. YouTube is YouTube. We have to work within the limitations and the sandbox that is YouTube. Barry, they have paints and canvases too for when I'm in that kind of artsy way. Crazy Mary Fetch used to get large pieces matted and framed at Michael's in Dallas. You're going to get rain all weekend? Jenny Lynn, we need to have a pet show until one day. Yeah, no, let's not do that. That puts no. We're not gonna do that. We're not gonna do that. All right, let's see. Megatasmom, the only craft stores around are Michael's and Hobby Lobby, with the small shops privately owned. All right, waiting for Judge Kite to come back. She is reviewing a 4-minute video, which was 20 minutes ago, 15 minutes ago, I guess 15 minutes ago. All right, let's see what else. Joanne's Fabrics folded. Oh, here we go. Looks like they're coming back. All right, just waiting for Mario to come back in, and then we will have Judge Kite back on the bench, see what kind of ruling she makes on this video. So I guess there was somebody took a video. I don't know if this is body cam or what this is, but somebody took a video of minor child BB. I think it was at the scene too.
Mr. Fernandez is back. Did you all have a chance to talk?
Briefly.
Okay. All right, so I did review the video that was submitted. My impression for purposes of the ruling is that the AB's first statement places her where both sides, I think, maybe agree, but then there's a second portion where the detective circles back, and then she makes the list of statements related to horrible person, all of those things. There isn't a lot of clarity that I was able to glean from either one of those segments of statements. She also, in the first set of statements where initially she places herself upstairs, I don't think that can make any findings related to that unless it's clarified. And so I think the state's request to proffer, unless it's clarified in a deposition, I don't think that I can make any sort of ruling based on that is Mr. Fernandez and Ms. Gardner's expectation of privacy.
It's the state's burden.
I agree. And so they're asking to proffer. What came to my mind is it clarified some other place besides this video?
Well, it wasn't, because at the time that AB gave her deposition, these statements had not been disclosed. They hadn't even been made yet. They were made a year, maybe two later. And additionally, we've always, even if I was deposing AB, this is the first we've ever heard of this theory. So the child abuse count was always BB. They've dismissed it. I think that's irrelevant, but there's never been an allegation that the children that we should be worrying about their physical or mental health was LB or AB. Never until this morning would have we ever asked a single question. We've never been provided a mental health record of LB or AB. We've never been provided a physical medical record of AB or LB. It would have come up in deposition.
Okay. So how are we going to rectify the problem?
Well, I think regardless of whether this is eavesdropping or not, it's admissible. I think the statement is pierced because they're talking about doesn't deserve to live. And we're going to be able to circle back by other evidence, and the whole concept of their statements about their discussions about Jared Bridegan centered on the custody of the children. That's what this was all about. I think the husband and wife privilege has been pierced regardless of whether this is an eavesdropping or they have an expectation of privacy or not. I think the court can rule about it. I mentioned only the proffer as the backup, which the court, we have no problem waiting until we put her on the stand to clarify this.
I think it's too big of an issue to wait. Number one, it's been brought in a motion in limine. Number two, so if the court follows the state's theory / analysis, okay, what is to stop the state from asserting this sort of theory / in any murder case where the victim has a child and then say, well, all privileges fall away because it would assert mental injury or mental child abuse against the deceased victim's child?
And that's a great question, and the answer is equally as great, because this murder was about the kids. If there's not evidence, if one defendant, a gang member, shoots another gang member out there on the streets, and there's no evidence that the shooting had anything to do with the child custody or the custody of that person's child, then husband-wife privilege would apply. Going back to the whole concept of a public policy, Your Honor, there is no public policy for husbands and wives to discuss the murder of one of their children's father. There is no public policy. Now, we got a little, I mean, it exists, the statute exists. Many other jurisdictions have a crime fraud exception to husband-wife privilege. The state of Florida does not, but it does have this abrogation. And this abrogation is, if this act is about children, then it's pierced. The whole concept of this murder is about eliminating his child custody, eliminating the father of these people's children, and that is an act that reasonably could lead to their mental injury. So it's not in every case. There is no slippery slope. How often do we have murders where the purpose and motive of the murder is to eliminate the child custody? How many murders do we have where we even know they have children? It has nothing to do with the children.
Is there any case that would stand for that proposition?
What?
Ever, I mean, this is not a new or novel motive, right? So
it is a unique motive, and it's very, very rare to have husband-wife privileges that have to do with the murder of the children. I think that's incredibly unique. It's a very rare set of circumstances. I think the case that I cited is the clearest example of where the courts are going to fall on this.
You said Hill.
Which is Hill, because it has to do with some, I mean, it's a reckless driving that they've alleged a child neglect to it.
But there's actual, like, within, it's not a motive argument, it's actual in the facts that the child was, in fact, injured. To me, that's an easier question than what you're asking this court to do.
Well, we have a child that has been injured as a result of this case, an act that reasonably could lead to their injury, because again, I think that the 39 pierces husband and wife privilege, regardless of whether it's their children or not. It doesn't matter whose kids it is. So we have two theories the court can rely upon. One is that BB was in that car with bullets flying by her, which is exactly like Hill, that the person's in the car with crashes happening right now, and that act of child neglect is pierced because of that. Now, I would concede that the discussions about the murder, which is what we're trying to introduce, don't relate to BB being in the vehicle. I concede that aspect. But we do have evidence that this was done, although not expressly made, this was done during a known date night, which the court is aware of, in which BB would always be in the car. One of the children would be in the car, and the murder took place when they knew the child was in the car. So we have that. But the express...
Aren't those facts kind of outside of my universe right now? I know it's part of your argument, but it's kind of...
Well, I mean, the courts have talked about how we have a trial before the trial. I mean, I don't know how else to do that.
No, what I'm saying is...
These are matters of the record. The court has heard plenty of sworn testimony in this case, and I'm not speaking outside of that.
Right, but the court is also not an investigator. Like, I can't comb through, like, all the hearings that we've had. It has to be kind of a part of the succinct hearing that I'm having right now. I can't go digging for the state when the state has the burden and its argument at this point. Like, if you want me to consider it, I think it has to be the universe of this hearing. I'm not an investigator.
Well, then the state would be introducing and asking the court to take judicial notice of all the sworn testimony in this case. We also will be filing all the depositions in the case. And we would ask the court to do that in lieu of live testimony, because we're going to have a trial in 2 weeks. I know that's a large burden on the court, but these are typically, when we're dealing with motion in limines, which is what the defense has filed, the facts are generally agreed upon, and that this is more of a legal issue.
Right.
I don't think the defense is disputing the fact that the state is going to establish that the motive for this killing was the child custody. We have evidence of that. That will be presented in the trial. And so the question then becomes, is the motive, I think the court has to answer one very simple question. That simple question is the motive behind a murder, if that motive is child custody of minor children, does the murder of that person pierce husband-wife privilege? And it's just that simple. And that's the legal issue I think the court needs to find. And if that is true, then of course, if we go to trial, the state's unable to do that, we undertake that in our peril. But we are going to be able to establish the motive behind this killing was child custody, and therefore the defendant's discussions about eliminating the victim was done for the purpose of child custody, which pierces under Chapter 39 and frankly under 507, I think it is. Thank you.
Say thank you.
I said thank you.
Okay.
It doesn't. 39, the abrogation of child abuse, does not pierce the marital privilege. In Jet, it pierces the psycho-patient theory, psycho-patient therapist theory. The psychotherapist is never going to have the child of one of that therapist who is being abused. So they rely on that statute. Mr. Mizrahi wants to ignore that you go back to the marital privilege statute, which specifically says a child of either. So now the BB, which now they've circled to a new theory that now it is BB, although that's the first I've heard of it. And now they're suggesting that it's because LB or AB could reasonably have an issue that they've never disclosed to us before, that's how it breaks the privilege, because that is a child of theirs. And then Mr. Mizrahi just came in and just told you facts that simply are not the case. He told you just a moment ago that the proffered evidence is that Kim Jensen would tell you it was a week ago. Let me tell you what Kim Jensen would tell you. They had different parenting styles. It was obviously, things were not perfect. And so they would have...
Where are you reading from?
I'm reading from...
I can submit the testimony from Kim Jensen in the hearing, as well as Kim Jensen in the unsealed grand jury proceedings, for your honor.
I bit my tongue, and Mr. Mizrahi did remind me during the break that we shouldn't interrupt each other, and yet I've just now been interrupted.
I was responding to the court's questions.
I had it in front of me. I think the court was asking me what I was reading from.
Well, if you're reading it, here you go.
You may continue, Mr. Dreiser.
So in relation on page 82 to the very dialogue that we put in our defense motion in limine number 1, they go on to ask her about when all of this happened. Now, in the very statement itself, she says, I don't know. He told her, if you don't want this to happen, I'm sorry, she starts with Mario told her, I can't remember exactly when the conversation was. Then, in their grand jury, they're pushing her, you know when it was in Hawaii, and this is what she says, bottom of page 82. They had different parenting styles. It was obviously, things were not perfect, and so they would evaluate whether or not they were going to stay married. And so I don't recall if it was that particular trip, or another one. I know that it happened, that conversation happened on a Hawaii trip. Which one, I wasn't sure. And the evidence in this case is they went to Hawaii yearly. So the idea that it's the week before, she says in 2 different spots. And in all of her testimony, she doesn't know when that statement was made. So they're putting facts and evidence today in this quasi-proffer that they want you to believe these things are true. That it is apparent that this is over child custody, because if you look to the divorce in St. Johns County, Mr. Mizrahi told you it would be apparent that they were having child custody fighting issues. No, it's not. There is no motions regarding child custody post-dissolution. And I'll explain with the exception. In this case, there is a marital agreement, consent order.
Discovery.
Mute yourself.
Mute, please.
Mr. Mizrahi. Your microphone.
So they come to a consent order, which means that there was no trial and the parties agreed to 50-50 time sharing. Then for a short period of time, Jared Bridegan moved to, I believe, Utah, and there was then a consent order regarding what the time sharing should be. Then when he moved back, there was a consent order that they have equal time sharing. And then there was a motion about what what school the children should go to, a medical device motion, every single one which resulted in a consent order being entered. These folks didn't go to court one time to resolve their initial divorce, which was agreed child custody, and any other subsequently post There is no motions that the court will be presented with that they were fighting that one person should have more time than the other, that one parent was unfit, one parent's time sharing should be eliminated because of drugs, abuse, nothing. That's what a typical family law, acrimonious post-dissolution is. This parent's a drunk, this parent's a drug addict, this parent can't fundamentally co-parent, is a parent alienation, all the things that you can imagine, they don't exist in this case. So what he just told you is not what the record reflects. We've agreed on what evidence is going to come into this case, and I have in my exhibits the marital consent final judgment as well as all of the motions and all of the consent orders to show the jury that in fact they want the story to be that. The media wanted the story to be that. That's not what the record reflects in this case. And in fact, my recollection is when I asked Detective Johns, the lead detective, if he had ever even read any of the pleadings in the family law case, my recollection is that he said he had not. So now they want you to adopt this idea that they have a new theory of how they can get in, and I'm going to go right into the co-conspirator statement, Judge. You asked me what happened to our defendant's second motion for bill of particulars, okay? We had a hearing on it, as you may recall.
I do not. We've had lots of hearings, Mr. Director.
I understand. Well, I will tell you that the motion was filed on December 24th of 2025, and we called it up for hearing on January 22nd of 2026. I went into great detail with the court. I went through my motion, and I went through the information which was at the time a 4-count information. I pointed out to the court that all of the folks that are charged all had different date ranges.
I do remember that.
I pointed out to the court that Mario Fernandez's was from November to February. I pointed out to the court that I have no idea why it's in November. I pointed out to the court that Ms. Gardner's was totally different. I pointed out to the court that there were unindicted co-conspirators that they've always alleged. I have known about this statement from Kim Jensen to Shanna Gardner about what my client supposedly said for years. I cannot tell you, and I will, as an officer of this court, tell you how many times I have addressed this with Ms. Stifler. And I will represent to you that after the day of this hearing, Ms. Stifler called me on the phone and she said, I'm not, in the court, by the way, in the record, this will be on the record, she said that she was going to respond. She said that she would outline all of the conspiracy date ranges. She said she would, and the record will reflect exactly what she said, and if we have to rush order the transcript, I will. But I will represent to the court that Ms. Stifler called me that day and she said, I am not trying to hide the ball. She told me on the phone, November, it's not a magic date. It's sometime when Henry Tenon suggested to us that Mario went to him and they started discussing it. And in fact, I learned for the first time that Ms. Stifler told me initially Henry Tenon supposedly said, I'm not interested. And then at some point he changed his mind and she told me there was no magic date. They just used November. And I said, okay, that makes sense. Then she told me who my co-conspirators were. And she never mentions Kim Jensen. I have asked her over and over again, because if Kim Jensen's not a co-conspirator of Mario Fernandez, then that statement can never come in. Today, there's this whole new argument as to who co-conspirators are, and statements that Shanna Gardner made to Kim Jensen. I tried to address this months ago, and I was met with a phone call that said, your co-conspirators are Henry Tenon and John Biggerstaff. And there is no evidence. First of all, you should know this has never been responded to. They have never filed a formal response. And when I was told last week for the first time that they were going to try to get in this statement from Kim Jensen, I was on speakerphone with Ms. Stifler and Mr. Mizrahi. And I said, you're now trying to get this in? And Mr. Mizrahi said, co-conspirator statement. And I said, oh, after 3 years of telling me that that's not coming in. They've now decided, without filing a single response to my motion in limine, or my motion for statement of bill of particulars, as to who is a co-conspirator of who. They have to tell us, independent of the statement. That's what the law says. Mr. Mizrahi provided the court with a series of cases, all of which I agree with. That is the law. Independent of the statement, they have to tell you who your co-conspirators are and when the conspiracy is. So now, Mr. Fernandez, the best I could guess from a count that has since been dropped, the conspiracy count, his conspiracy goes from November 2022 to February of 2023. So it's essentially a less than 3-month conspiracy. Now they want to come in and tell you that all of the statements that Shanna Gardner ever made to Kim Jensen should come into evidence because they're co-conspirators of one another. Those statements go back years. So what is it? Are they now just telling you and me for the first time, a week before trial, that Mr. Fernandez's conspiracy goes all the way back to 2016 or 15 before he even knew her? Which I agree is legally possible. You can join an ongoing conspiracy. But they haven't done that. The best they've ever told us is that my conspiracy is from November to February. So is it for the first time today that we're learning that he joined an ongoing conspiracy? Or do I think what their theory was all along until they've recently changed it as they prepare for trial? That there were 2 conspiracies. There was a conspiracy between Kim Jensen and Shanna Gardner, and that they, perhaps the object of the conspiracy was to have Mr. Bridegan killed. And then their theory was, well, once we had Henry Tenon, we have an agreement between Mario Fernandez and Henry Tenon that they want Jared Bridegan killed. That is a conspiracy. That is an agreement. It happens between November. It happens up until February. And now the object of that conspiracy. And they were fine, and it was simple, and it was clean. And their theory was certainly that those are who your co-conspirators are. That's the date range of your conspiracy. And those are the statements that we would be able to get in. But not what they're telling you today, not what they're telling me today, and they've never filed a single thing to the contrary to tell me, when did Mario Fernandez make an agreement with Shanna Gardner to kill Jared Bridegan? It's never been disclosed. When did Mario Fernandez make an agreement with Kim Jensen that they want Jared Bridegan? When? It had to be between November and February, unless today, for the first time, the week before trial, they're going to tell me that my conspiracy goes back years, Judge. Which, if they're baiting me into a motion for a continuance, I guess that is where we're at. Because we're now talking about what could be perceived as thousands of messages between Shanna Gardner and Kim Jensen as to what their whole plan was before Mario Fernandez may have even met them.
Let me stop you. Is that what the state's doing?
Are we done with the husband-wife privilege, or we want to go?
I believe that we've transitioned into the bill of particulars.
Your Honor, we abandoned the count. We're happy to provide a bill. We abandoned the conspiracy count. I don't know what we're talking about now.
Because the conspiracy, it's irrelevant. The conspiracy count is irrelevant. The law says...
Wait. I asked Mr. Mizrahi. Go ahead.
Yeah, the answer to the question is the conspiracy doesn't need to be charged.
Well, so he's asking, in the universe of facts that's going to be tried in a week, what is the state relying on? Because apparently y'all are on 2 different pages.
My job is not to sit down with them and tell them how I'm going to prove my case. My job is to make sure that the evidence that I'm going to use has been disclosed. There is not one thing I have mentioned that has not been disclosed. The court is aware of all of it. Just said, his argument, I have known about these statements for years and years and years. Well, that's what we're relying on. The years and years and years of discovery statements where we see that Kim Jensen and Shanna Gardner discussed how they were going to kill Jared Bridegan, and then brought in, pursuant to the defense's own acknowledgement, that 2 people can be in a conspiracy, and a 3rd person can be brought in later. We agree Mario Fernandez was not part of those original discussions because he wasn't part of the conspiracy. Shanna Gardner didn't even know who he was. But when that discussion about killing Jared Bridegan, when she married the defendant, Mario Fernandez, she brought him into the conspiracy and continued to provide updates to Kim Jensen, her other co-conspirator, about how Mario Fernandez had planned on doing this. So all of those things have been disclosed. I don't,
I agree. So what I also hear, and what I'm asking the state, is that Mr. Dreiser says that he's filed filed 2 motions for a bill of particulars. Neither one have been responded to except for informally. He's saying that the state has given him, I guess, an assurance that whatever is in the universe of facts would not be used against him, and therefore we've got to, I mean, I do believe, I think both of you are right in separate silos, right? Like, so yes, of course, everything is within the universe of facts, but if the defense asks through motion and the state says that they're going to respond, I think that you do have to respond.
We responded by dropping the count. We're happy to respond to the solicitation count. I don't think that's what the defense is asking. If they are, we're happy to send an email, do you want us to respond to that? Because we're happy to respond to the solicitation count. We've abandoned the conspiracy count. How are we doing a statement of particulars as to the count that we've abandoned? Now, the conspiracy count has nothing to do with it. What the defense is essentially saying to you is we weren't prepared for this issue.
That is not what we're saying.
And that we were not anticipating this coming in. And the argument is that the statement of particulars should have told us this.
Well, you have. I thought you did tell him, and that's why the motion in limine has been filed.
Exactly.
Okay.
I'm saying before.
Okay.
He's talking about the motion in limine from 2 years ago. I say motion in limine, I'm sorry. The statement of particulars. That's what he's referring to, this, that he would have known about this years ago. I don't know what to tell him. We've abandoned the conspiracy count. We're happy to respond to the solicitation count, although I don't think it's going to provide him any more information than is already provided within the indictment. Shanna Gardner, the question the court has is, has husband-wife privilege been abrogated because of Chapter 39? Really doesn't matter if it's 39, because our main theory is that they're talking about their kids. So whether it's 39 or the husband-wife 90.50, a husband-wife, it has to do with their own children. Whether the discussion under a motive of murdering someone pierces them. And that's the goal of the murder, is to eliminate his custody of his children. Is that talking about suspected child abuse? And then if it is, then the next question, because that's not the only question, the next question is, does this qualify as a co-conspirator statement? And I think that is very clear. And I started to go into that. We were able to establish a conspiracy with Shanna Gardner and Kim Jensen, where Shanna says, offer. Kim Jensen accepts that by reaching out to a third person and saying, do you know anyone that can help me with Shanna and getting rid of stupid? We've seen all that evidence. So we have that conspiracy between those two. That conspiracy never terminated. We provided the court the Epps case. The conspiracy exists until it's consummated, abandoned, or terminated. That's 354, 7th, 2nd, 441, 1978 case, First District Court of Appeals. This is well-settled law. And then the defendant, Mr. Fernandez, is brought into that conspiracy that is never consummated, abandoned, or terminated, and starts to provide information about how he's going to kill, paraphrasing, get rid of the victim in this case, again, for the purpose of eliminating his custody over their children. And those updates are then provided to Ms. Jensen. The Gardner provides those updates. This is what my husband is saying he's going to do to accomplish what we have already conspired to do. And then the statements, as already indicated, Ms. Jensen says in her grand jury testimony that has been unsealed, as well as her testimony before this court in the hearing, is that Mario Fernandez was talked. Again, that goes to the weight, not the admissibility. He was a bragger, he was joking, I didn't believe him, all that stuff goes to the weight, not the admissibility. He said on repeated occasions to Shanna, who then repeated it to me, that we were going to accomplish this. Hold on. I know the court heard everything and everyone in the court could hear it, but we're concerned about other things. So I've provided the court the idea of what is necessary to get in co-conspirator hearsay. And adding people, I cite Cam v. State, which is 1983, provided to the court, 433 Southern 2nd 38. It's a First District Court of Appeals. Adding more people to the conspiracy doesn't change the conspiracy at all. And then more importantly, I guess, to respond, and I did not provide this case, I can later, but the conspiracy, and I think the defense will acknowledge this, that the conspiracy need not be charged in order for co-conspirator hearsay to be admissible. And I think we all acknowledge that. And that's Brown v. State, 648 Southern 2nd 268, 1995 4th DCA case, as well as Richardson v. State, 338 Southern 3rd 1106, a first DCA case. I believe Your Honor may have been the prosecutor on that case, Richardson v. State. So the conspiracy doesn't need to be charged and alleged or have a statement of particulars to respond to it. The evidence, everything that I've talked about has been disclosed, and we are able to establish the conspiracies by independent evidence. And once we're able to establish the conspiracy by independent evidence, it's admissible, as long as it's a statement in furtherance of the conspiracy. Thank you.
Okay, thank you.
What they're telling you is that because they dropped the conspiracy count, they no longer have to respond because I'm not charged with a conspiracy anymore. So therefore, I then don't have to tell you what the conspiracy is, when the conspiracy was formed, who is in the conspiracy. Who in their right mind, we both agree you don't have to charge it with a conspiracy. Who would charge a conspiracy if you could just go on and leave the defense to guess? And to call our team unprepared on this issue when you're sitting in front of a motion where I literally write, Mr. Fernandez is not asking the state to provide its theory of the case or how it will prove the agreement existed, but rather what fact, act, or agreement the state alleges was made constituting the beginning of each co-defendant's charged conspiracies, to suggest that I'm just afraid or unprepared going into trial when I brought this to the court's attention, filed it, called it up for a hearing, was given representations, so much representations, you know how much work the defense has done. You know how many depositions we've taken. You know the lengths that we've gone to take depositions. We've never deposed Kim Jensen because we didn't think we had to because of the representations that were given to us that they weren't using her statements because she wasn't a co-conspirator of Mario. And what Mr. Mizrahi in all of his case law says, that in order for a co-conspirator statement to come in, Kim Jensen, the declarant, has to be a co-conspirator of the person giving the statements, has to be in the same conspiracy as the declarant or the person making the statements. So they have to prove independently that Kim Jensen is in the same conspiracy as Mario Fernandez. And now because they're telling you, well, we abandoned the count, the time doesn't matter anymore. So now, this whole time, I'm basing it off of November to February, and I guess now their theory is, well, we dropped it last minute so we can go back 5 years without ever telling us, which we've asked for, what agreement. Mr. Mizrahi just keeps talking about things that Kim Jensen and Shanna said. And then, well, this is when have you heard one thing that Mario said to Ms. Gardner that would link him to this conspiracy? What act or statement did you hear that Mr. Mizrahi said that would link Mario Fernandez to Kim Jensen? I have to know when that was, and I have to know what it is. I don't need to know their theory, but I am entitled to that. So Ms. Gardner and Kim Jensen and all those comments and all the testimony that he says, yeah, we're aware of, sure, but it didn't apply to us. Because it certainly wasn't November to February, and they just want to have you say, well, they gave it all to you. In what context? Years? So the first time we're learning today, they did file an information. Whether they abandoned it or not, they filed it, and they've represented to us. In so much, interestingly, Mr. Mizrahi brings up the statement of the second count, which is the solicitation charge, and he says, I'll be glad to tell you, I'll be glad to tell you. It's in the jury instructions that they provided in the draft. And it says between November of 2021 In February of 2022 is when Mr. Fernandez solicited. Now he's telling you. So in the jury instructions, they gave you a draft of this week and gave me a copy of. They're telling you, no, it could have been years. It could have been years. How? That's what I'm saying. They don't have to tell me their theory. I have been given a lot of this information. They have to tell us to get in co-conspirator statements. You can't abandon the theory that you have to prove a conspiracy existed. And in order to do that, you have to give someone the time period of the conspiracy, and you have to tell people the act or the agreement. And that's what I've been asking for, and I was wholly misrepresented as to what their theory was and who our co-conspirators were.
Okay. Taking these issues in total, from the defense perspective, which one do you think the court should resolve first?
The marital privilege, because if you find that the statements are marital, they were made in confidence, the state hasn't met their burden, Ms. Jensen's statements don't come in. If during the trial they decide that they're going to start loading all of Shanna Gardner and Kim Jensen's statements or text messages, which they haven't provided to us as an exhibit, so I don't know why they would be doing that, then we have to raise this co-conspirator hearsay issue. But if you find that it's marital, it's moot. If you find that AB statements, that one I do agree that if you want to wait and you need more evidence from them, I mean, today is the day, but, you know, I'll let you decide on that.
I wasn't sure. So the ask was for me to review the video. I don't think that really resolves anything related to, at least from the court's perspective. I think her statements, obviously they're short, but they also implicate a number of statements, where they were made, how they were made. I don't think any of those issues are resolved with that video. And then, you know, Mr. Dreiser had his notes about it, but it's in two different segments on the statements, and I didn't know, that's what I was asking, so I didn't know if they were resolved with a deposition, but now I understand why not. But I would definitely need some type of, before I even kind of went down that road, I don't know how I would resolve these issues with AB.
I think the best way to do it is to see if we can develop. I mean, we can try to do it on our own with the parties beforehand, but I mean, you know, we can also do it in trial. I mean, it's not something we have to mention or go and talk about. And I know the court wants to resolve all these issues. We're also talking about a minor, and then the administrative rules in Florida statutes encourage us to limit the amount of times that minors are discussed, and I'm very cognizant of that. So I mean,
I also agree, but also what I'm hearing from both sides is that Mr. Dreiser said the deposition that he participated in and took of AB wasn't contemplating these issues. I hear the state saying that you always knew.
That's not true, no.
Or like that you knew that you were going to introduce this state. You did not know.
Those statements were provided to us after the deposition.
And Your Honor,
A year or so.
Right. This is a long time ago.
we deposed AB and LB, I think in early 2025, late 2024. The state's 10th supplemental exhibit, September 19th, 2025, listed the interview that I provided to Your Honor. And in section C of the state's discovery exhibit, it lists the specific statements outlined by Mr. Dreiser. So the state put those statements specifically outlined in a discovery exhibit dated September 19th, 2025. I think we had some discussion about a follow-up deposition.
When was the depo of AB? You went fast.
Let me give you the exact date, Your Honor.
September.
It was before those statements were
Yes.
disclosed.
Way before. I want to say like close to a year.
A year.
I recollect.
So the deposition of AB was September 20th, 2024. The state disclosed the
September 19th.
September 19th, 2025, the specific statements as relayed in AB's recorded interview, including statements that, quote, he would be better off dead, statements he has a right to die, doesn't deserve to be in this world, was a horrible person, and the defendants would not feel bad if he died. I spoke to Mr. Carodi this morning about, obviously the state has no access to AB, and I don't believe Mr. Dreiser had access to her Mr. Crody, we were discussing in preparation for trial, the ability for both sides to pretrial with her. So perhaps that might resolve some of these issues if both sides are allowed to speak with her and develop some of these issues, short of a recorded deposition, but in an informal Zoom pretrial setting, which I believe there's been at least a loose openness to making that happen.
Mr. Crody?
Her guardians.
Do you know?
What's the question, whether or not?
If AB can be available to both parties to resolve some of these issues so I can make a ruling.
Your Honor, I'm not in a position to make a representation, an absolute representation to the court. I can obviously pass the information along, stress that that would help resolve an important legal issue.
When would you know?
Hopefully by close of business Monday.
It takes that long?
Helpful for the court to know that involved in this from the beginning. The Gardners have their own lawyers, and you can't just call like a normal parent. You have to call the Gardner family lawyers, and the family lawyers meet, and the family lawyers talk to the family, and then the family gets back to their lawyers, and their lawyers get back to us and the state. It's not, and the state is acknowledging that is the course, and they're entitled to do it that way, but it's not as one of these normal issues where you just say, go in the hallway and call so-and-so's parents and see if we can talk to them. It just doesn't work like that. And she's on the West Coast, so there's a time difference. There was, I think, summer now, so there may not be those school time issues. So when we did her depo, we did it, I think, starting at 5 p.m. or 7, or it was late on the East Coast. So there's just more issues than typically we see.
So, Your Honor, I will,
So right now, what is it, like not almost 9?
Your Honor, I also believe there may be some travel involved currently. So again, as an officer of the court, I don't want to represent the court.
No, I
happen. So do I
just asking questions.
By Monday, by the end of Monday, I can have an answer and communicate that to the parties in the court. I can tell you there were preliminary discussions with, is Ms. Stifler represented, with one of the family representatives, and I think there was understanding that giving access to AB pretrial to all the parties would be in the pursuit of justice and be fair to everyone. So I can pass along as I get information.
All right. Thank you. I'll need to see you. I want the answer, Mr. Crody, and then I need to see you all as soon as you know the answer. So maybe Tuesday.
Yeah, whenever the court is available, the state will make itself available.
And then I'm also hearing that there's no settle agreement related to the motion for a bill of particulars, both the first or the second. So I'd ask the state to respond. Before I thought it was settled, like you all were. So if you would respond to that by that date.
No problem.
So I'm going to take the motions under advisement.
Your Honor, as Ms. Nelson alluded to earlier, the Gardner team is unavailable to appear next week, and if we could appear by Zoom and waive the appearance of.
Absolutely. I just need it. Honestly, all I need is for, to the extent that you, Mr. Crody, to the extent that you have contact with AB, that you communicate that contact to Mr. Dreiser, the Fernandez team in the state, and then you don't have to be here as far as I'm concerned.
Yes, Your Honor, and for the record, the lawyers do not have contact with AB for Ms. Gardner. Like, we do not have access to her, unfettered access to her. So we will be communicating with the representatives of the family.
Does Mr. Dreiser, does the state have to go through you, or could they contact those lawyers?
They could contact those lawyers.
Why don't y'all do that and just take them out of the loop then?
That would be fine. I've been I've been coordinating through Mr. Karodi, who is courteous enough, and that's how we did trial subpoenas, both Mr. Dreiser and myself, and the Zoom stipulations we went.
Why don't we cut out the middle team that doesn't have direct access?
I did ask for some contact information. If they can provide that to me, I'll do that. That's fine.
I will say, Your Honor, that we adopted the motion with respect to marital privilege, so we're involved also and will be participating anyway.
Would you all be, meaning participating, you want to make your own arguments as well? And if there is if there's proffered information, I don't really care the form, but I do care about, generally speaking, motions in limine are hard to rule on regardless, because generally speaking, the court needs some type of context. This, I thought, was purely legal, but part of it relates to some factual determinations, like how, a lot of times the facts are just agreed on.
Yes, Your Honor. As far as argument on the motion, and we've adopted the motion with respect to the conversations that occurred in the home. Obviously, we are in a different posture with respect to the communication alleged by Ms. Gardner to Kim Jensen.
Yes, I agree. I'm speaking solely related to AB, solely related to, because, hypothetically, how and when these conversations occurred, it sounds like no one explored. No one knows. All of it is assumption. And so if it was like made in the open air in the kitchen and she wasn't upstairs, was there a marital privilege? That matters,
Yes, Judge.
If it was behind a closed door, as is one of the cases, that matters. And no one's explored it. No one, do y'all even know the answers?
I mean, when the detective said, the detective asked if they ever talked face to face with Abby about stuff like that, she said no.
Right, but stuff like that, she could interpret that meaning like they talked directly to me, not I was sitting in the kitchen while they were talking while, whoever was making spaghetti dinner.
Well, it was 25 seconds.
Right.
Like the same conversation.
Well, as lawyers, you all know that direct questions to direct answers, she also said they talked about it for a long time.
Right.
So that the way that police question and the way that lawyers question, two different things. Unless y'all can agree that is like, that all the statements were made and she was upstairs in her master bedroom and all of the statements they were separated and downstairs and that they weren't intended, then I don't know how to even rule.
Yeah, none of the parties know the specifics to that answer. We can endeavor to do that. The state's position on all this is that it's irrelevant except as a backup. So if the court were to find marital privilege for all these things.
I'm interested. I guess this is the first time I heard the state's theory, because I was always kind of operating that it was BB.
Right, so, and I want to point there, because we have taken the deposition. I don't want to spend a lot of time arguing about why we think there's a conspiracy between the defendant and Ms. Gardner. I think the court is aware that there's discussions between the two of them about Jared Bridegan's elimination. We have a specific piece of evidence that is new to the case that we filed our 18th supplemental discovery on. We have taken that witness's deposition. We have not gotten a transcript yet. But in the state's disclosure, I want the court to be, this is directly from the defendant's mouth. So this is substantive evidence of the defendant to this witness that defendant stated that his wife wanted to put a charge on the victim, that he told her they should just kill him. Fernandez stated they didn't want the victim around because of the kids. So that is, I just want the court to be where we do, and the defense is going to have a lot of cross-examination on the credibility of all of that. But we do have independent, direct evidence that the defendant was doing this for the purpose of eliminating the custody of the children. Therefore, state's theory of abrogation of the husband-wife privilege has been met, as previously argued. But we do have evidence the court can look at in our disclosures.
Would you agree that those statements were made?
No, I would not agree that those statements were made. I agree that some 12-time convicted felon heard those statements supposedly from my client in 2024 when he was actually cooperating in another homicide case with that office and doesn't disclose it, gets out of custody, comes back into custody in late June of 2026 on a $5 million bond, and then reaches out after telling his mother to Google it, and then calls the state and says, get me a meeting. And then about 10 days ago, we find out that this snitch from 2 years ago has information, none of which is information that you could not have found on the news. So no, there is not a juror in the world that will believe this person, nor do I believe it would even make the threshold. It's not even a weight for the court to determine the weight of evidence to allow theories, especially in context of a co-conspirator statement. There has to be independent evidence by a preponderance of the evidence that there is a conspiracy, and then whether or not those statements can come in, I don't even think it would make muster with the court of how incredible this human being is. So if that's how they've come up with their new theory, it is, it's so factually disgusting that no one would find it to be credible. And I look forward to them putting that person in front of the jury as to their final admission that they got from Mr. Fernandez, because I don't believe there's any other statements between Mr. Fernandez and Ms. Gardner that they intend on admitting, where he says there's lots of conversations between them as to eliminating Jared Bridegan. There's not. I don't know what they're talking about. There isn't in this case.
Okay.
And I be heard? Just briefly.
Yes.
I heard Mr. Dresser just say the answer to the court's question was yes. There is evidence of that. Whether it's credible or not is a different weight, not the admissibility. There is incredible evidence of a conspiracy in this case beyond the defendant's own admissions that because we're talking, it's hard when you have two different issues. So the regard with the custody issue is not just proven by that person, but is proven by the circumstantial evidence. We do have direct evidence from the defendant about him stating that he was there to help with child custody issues, that he would take care of child custody issues. It's not just this witness. We have multiple witnesses that would testify to that. But we also have overwhelming evidence that there was a conspiracy in this case. We know that multiple people were involved. When the victim was killed, there's a person that fled on foot and a person that fled in a vehicle. We know that Henry Tenon left his DNA behind on that tire, and that we know that Henry Tenon was not driving the pickup truck that fled the scene. And we know that the defendant, Mario Fernandez, has a connection with Tenon based on the relationship of being landlord-tenant, but also their communications between each other. So we know that they have communicated in the days, weeks, and on the day of the particular crime and afterwards, which afterward statements are not conspiratorial in nature. But we have the other co-conspirator, Shanna Gardner, and this defendant, Mario Fernandez, being the LLC co-managers of the account that ends up paying Henry Tenon. So when the court, all of this evidence establishes the conspiracy. It's just the most easiest one to do it is the jailhouse witness. I want to also, I think I pointed this out before, the reason why Kim Jensen involved in conspiracy is she, independent of the ask to find somebody, actually asked. So she took the affirmative step of her own to try to find a person, which shows that they were involved in a conspiracy. So we have ample evidence that both of these people are involved in the conspiracy, and the conspiracy was with regard to the children. And in other words, eliminating the child custody issue. That's the only motive in this case that is really pertinent and significant. And so for those reasons, we don't think the court even needs to get to the finding with regard to AB. However, of course, it's always better to have more reasons to admit evidence than less reasons. And so if the court wants to figure out if that husband and wife privilege was abrogated based on a lack of expectation of privacy, we will endeavor to do that to see if we can provide the court more information.
Okay. So you do agree, well, you're agreeing the marital privilege obviously has to be resolved prior to, but before I was under the impression that there was some sort of understanding between the parties, so I am going to ask the state to, in short order, respond to the motion for bill of particulars, okay?
Not to ask to the solicitation, we'd be happy to do that.
We have to know how they're getting in co-conspirator statements. It doesn't matter whether it's charged. Ms. Rahi brings that to the court's attention because that, in fact, is the law. Whether it's charged or not is not the analysis. It's whether or not they intend on establishing independently with the evidence in this case that Kim Jensen and Mario Fernandez were in the same conspiracy. Every single case Mr. Mizrahi provided you says that that's what they have to do. So it has nothing to do with the solicitation. If they want to get Kim Jensen to make a statement about what Mario Fernandez said on the theory of a co-conspirator statement, they have to prove independently without that statement that Mario Fernandez and Kim Jensen were participants in the same conspiracy. And I think if you're going to make that argument, you got to tell me when the conspiracy was and what the date range was. And certainly, although there's circles being thrown in the air of what Mario and Henry Tenon have going on and what Shanna Gardner and Kim Jensen, I keep referring back to, you have to link the parties. You have to show that Mario Fernandez joined the conspiracy of Shanna Gardner and Kim. And the only thing that Mr. Mizrahi said that even had a scintilla of argument as to suggesting that they were joined was a payment that exists after the conspiracy ended, because I once will again say they listed it from November to February, the date of the homicide. The payments are in March. So the one thing that he said that possibly could link the two are outside the conspiracy date ranges.
So I'm looking at the second bill of particulars. It is related to the conspiracy, not the solicitation. It's a request citing the law. So to the extent it's in the papers, I'm asking the state, ordering the state to respond to it.
Our order has been filed by saying we dismiss that count. There's no law under the statement of particulars that we give a statement of particulars as to an uncharged count. That's nonsensical. So I can't provide a statement of particulars on a count that we've dismissed. And Mr. Dreiser is although 90% of the arguments on the legal issues he's been 100% right, 90% right on, he's 100% wrong on the fact that we have to prove that Kim Jensen and Mario Fernandez Saldano were in a conspiracy together. We have, in the case law, is very clear. We have to prove that they are in the same conspiracy. So, as the court's aware, in drug cases, you're going to have multiple people along the train of distributing narcotics that may not talk to each other. So, we do not have to prove that Jensen and Mario agreed together. We have to prove that Kim Jensen and Mario Fernandez Saldano were both part of the same conspiracy, which that conspiracy is the elimination of Jared Bridegan.
He's 100% correct.
Okay, yeah, there you go.
What he's wrong about is they have to prove that Mario Fernandez joined that conspiracy. He's right. They have to be in the same conspiracy.
I just have an issue. So I'm looking at the actual file document. And if the state's response is that we've dropped that count, then that is a response. And if you want to amend it to what you're asking, we're getting far afield of like what's in the papers is, I guess, my point.
Yeah, the statement of particulars, I believe, is a non-issue at this point. I have provided the evidence to the court, and it's already part of the record, about how Kim Jensen and Shanna Gardner were involved in the conspiracy.
Are you filing that? You want to file these?
What?
What you handed up.
We can. I mean, I think they're already, they're already part of the record. I mean, it's the
What I would like to do is instead of, and it's for ease of myself and probably the environment, okay? Like if y'all have transcripts, you can give me an electronic version. It's easier for me to search and look. So.
I mean, we need to, for the.
So I want what is in the record to be complete. To me, that was part of the reason today. So what's in the, I'm looking at the defendant's second motion for bill of particulars. It relates back to the first one, which talks about the inconsistent dates of the conspiracy. And so that was the ask. And then, so whatever the state's response is, let it be responsive to the papers. And if the state's response is that we dropped it, okay. If you want to amend, amend. And then we're going to be dealing within the scope of what's before the court. And so I'm ordering the state to respond the way you're going to. And then whatever the response is, but we're way out in left field.
All right. We'll just know that the trial will be filled with constant, which is fine. That's our job, is to constantly object, and we will, to every single statement that they try to get in until they independently prove that there's a conspiracy. And we'll just guess when that is and hope that.
Or we can try to handle it pre-trial with your papers, but right now, what is before me?
I'm ready for trial.
Okay.
Let's go do that.
All right, but
Response.
I'm going to request, and I'd like, if you all are going to impeach, I'd like for it to be electronic if it could.
Understood.
All right. I can return these back since you're.
Yeah, we'll do it because we have more to submit the bond hearing and things like that if the court wants to look at the.
If you all also, the transcripts, if you could OCR them so they're searchable and put them in order. Like, for example, what I'm asking is if, for example, witness Miss Jensen, if she's got 3 transcripts, okay, put that in a folder for me so I can click on that so I don't have to search between files. So witness has multiple transcripts, put it in a folder for me so that it's organized that way and I can find it quickly to rule.
And there, if we're moving on from this issue, we do have a state's first motion in limine.
Okay. I'm going to take 10 minutes, okay?
If I may, I'm going down to Judge Cooper's courtroom real quick. We started detention at 1:30.
Okay.
And I'll be right back.
Sure. All right, court's in recess.
All right, they're taking a 10-minute break, and we can go through some of your answers, or I should say questions. And I have, so Kim Jensen, she gave an interview with law enforcement, and we so want to show that, but we're trying to, we asked the content creator who obtained that, and we haven't been able to secure that yet. But here are some of her texts that they were talking about. In 2015, right? So they got married. So Shanna and Mario got married 2018. So in 2015, May 20th of 2015, Shanna says, I'm just not having a good day. Kim Jensen says, don't write the day off as bad yet. I'm still trying to send stupid to prison. Kim Jensen says, if I can't make a casserole, prison is the next best option. Then here's a Kimmy and a Susan Lee. I was thinking Thomas. This is in 2016. He isn't a magician, but I'll ask if he knows any. I'm sure her ex knows a few. Here's another one from 2016. He hates him. If not, I know Sue's husband knows people, LOL. Just when I think doing this whole week one-off thing is a good idea, it gives me a great pleasure imagining slitting his throat. All right. Here's Kimmy, the kind that performs permanent disappearing acts on certain people. No, any magician. Susan Lee says, magician. No, that I do not. For stupid, Kimmy, I was thinking Thomas, LOL. So these are some text messages that are out there. Hey, Janice, how are you? Welcome in. Good to see you. So they were talking about possibly getting rid of Jared well before Mario came. Well, I don't know when they met. They got married in 2018. I'm not sure if they met before that. I'm not sure about. But they were going back and forth with A, B, and BB. Those are the minor children. The twins are about 12. There's a boy and girl, so they're about 12. And then and that's from Jared and Shanna. And then Kirsten and Jared had another child, a baby girl, and she was in the back seat. So she's in the back seat when this all goes down, and she is BB. They're referring to her as BB. Now, what I'm trying to wrap my head around, and Barry is asking questions, and we're talking about this. From what I understand, she gave, from yesterday, they said that there was some kind of interview at the scene, and that's what they're going to bring into evidence. But if a 2-year-old, how could they expect a 2-year-old unless hold on, let me see if I can. That was from yesterday's hearing. Let me see if I can find that. Because they were talking about the minor children. The video of child at the scene will be sufficient. So, Barry, to answer your question, this was from yesterday. State will not call minor BB. Both sides agree to that. The video of the child at the scene will be sufficient. So this was yesterday. This was specific to yesterday. So I mean, that she was 2 years old when this happened. How is it? I guess, I mean, a 2-year-old, because remember with Donna Adelson and children don't form memories until like 4 or something like that, or I don't know. But I guess at the scene, maybe she was like, she was probably crying because she almost got hit by a bolt, hit by a projectile. So maybe, and she saw her father. Kirsten still, I guess, to this day is saying that she asks, where's my dad? Where's my dad? So maybe at the scene, maybe it's a body cam. Maybe it's body cam. That's what the state's going to use. So, Deb in Indiana, yeah, you remember that too. Yeah, I have that in my notes. State will not call minor BB. Both sides agree. They stipulated that the video of the child at the scene will be sufficient. However, the defense does have a minor child that will appear via Zoom. So they do have a minor child that will appear via Zoom. So I'm thinking maybe it was a body cam. Maybe this poor girl is like obviously frightened and crying, and maybe she's like, my daddy, what's wrong with him? Why isn't he getting up? I have no idea. I have no idea what's going on. But apparently that they're not going to call her, but they're going to use whatever video at the scene will be sufficient. So. Yeah, Jenny, yeah, maybe very short. What happened? My daddy fell down. Yeah, I heard a loud bang. I heard a noise. It sounded like a fire. Well, she probably doesn't even know what fireworks are. I heard a noise and it scared me, and then I saw my dad fall down. Yeah, something like that. That's what I'm thinking as well. Right? Yeah, that sounds right. Probably a body cam. Yeah, maybe something like that. Grizzly Grandma, if it's traumatizing, a child can remember. I remember things that I wish I didn't. So they were arguing, and Judge Kite, yesterday, we thought she said she had a sentencing at 1. So I don't know what she's doing, because it's 20 after 1 right now. So if that person is getting sentenced, they're like sitting there waiting for her to show up. So yeah, so they were just going on and on about, I guess it was the older child overhearing Mario and Shanna talking about hurting Oh, the child said horrible person. So they were going on and on about, is this going to be admissible? Apparently the defense is saying, oh, the state just brought this up. They literally just showed it to me. It's AB. Defense asked, and he says her name, but we'll go with AB, if they ever talk specifically about stuff like that. And she said no. Oh, law enforcement. Okay, so the defense, okay. Law enforcement asked AB if they, meaning Mario and Shanna, ever talked specifically about stuff like that, and she said no. But both parties don't know the answer as to when this conversation took place, so they don't know when. So was she? And then Judge Kite's like, well, was this in the what did she say? Wow. Kitties are going crazy. Was this in the kitchen when they're making spaghetti dinner and it's just in this, random, open space, and then the child's up in the master bedroom, or were they up in the master bedroom and the child's listening in through the door? And nobody knows. Nobody knows the answer to that question. So both parties don't know the answer as to when this conversation happened. But the state says we do know that Henry Tenon's DNA was on the tire. He wasn't driving the truck when it left the scene. So they say the state says they've got some really solid evidence. And his last name is Mizrahi. The gentleman that was talking, he's Alan Mizrahi. We also have Christina Stifler. She's the female. Alan Mizrahi is the male. And then Mario's attorney is Jesse. Is it Jesse or Jess? Dreiser. That's Mario's defense. So interesting. We'll see. And Judge Kite did look at this 4-minute video. She looked at that at the last break. It got a little spicy. Defense, are they goading me into asking for a continuance with this new theory? So apparently this is a new theory that defense is saying state's throwing on them. He says, there's thousands of messages we'd have to go through, which I suppose. Let's see. Defense is saying they're saying, defense was saying, the state is saying, because they dropped the conspiracy charge, then I don't have to tell you when the conspiracy formed and by who. Meaning the state doesn't have to. So just because they're dropping the conspiracy charge, they're saying, well, we don't have to tell you when the conspiracy started. Because were they talking about this? It sounds like Shanna was talking about this well before they got married, meaning her and Mario. I want to find out when Jared. I need to find out when they got married. When did? So when did they get married, and then when did they separate? So they got married April 2020. They were married 5 years. All right, so we're gonna. They were married until 2015. So this is some good info. All right, let me just put this down. As we get closer to this trial, this is going to be good for all of us to know. Let's see here. So I'm going to drop that here as well for you guys. All right. Hey, Marianne, welcome in. You have closed by Isaac Mizrahi, yeah. Same last name, I think. Or maybe, I don't know if he spells it the same. All right, so April 2010. So they got married in Salt Lake City. They got divorced February of 2015. Oh, and that one text message we were reading, that happened in, when was that text message? That was May 20th. So they got divorced in February of 2015, and that text message of, sorry, I'm waiting for the AC tech to get here, and I don't want to miss his call or anything. All right, so May 20th, 2015, that's when Shanna's saying, I'm just not having a good day. So they got divorced in February, and then she's saying in May, I'm not having a good day. And that's when Kim Jensen says, don't write the day off as bad yet. I'm trying to send stupid to prison. If I can't make a casserole, prison is Prison is the next best option. So, all right. All right. Forks and Facts. I'm so glad to see a live chat about this hearing. A new subscriber, awesome. Thank you for jumping in and popping in. Really appreciate that. Thank you for your support. Thank you. Hellrider, I've missed so much, but with well, I won't call him famous, but with my recaps, appreciate that. William says, "Who takes 7 years to carry out a conspiracy?" Conspiracy could be any number of years. I don't think there's any time limit. You know, there's no time limit on that. Could be any amount. Oh, but here you're saying, argue the statute of limitations ran out of the conspiracy because they talked about it in 2015. Crime took place in 2020. I think it has a 4-year limit. Well, let's look it up. Is there a time limit for... Let's see what happens here. There is a time limit for charging criminal conspiracy in Florida. It's determined by the severity of the target offense you allege conspire to commit. Under Florida law, a conspiracy charge typically carries a statute of limitations of 4 years for a first-degree felony, 3 years for second or third degree, and no time limit at all if the planned crime is a capital or life felony. So there's the answer. So it's 4 years if it's a first degree, 3 years for second. But it's this is a capital. This is a capital felony, so that's why. That's why there's no time limit. So that's why there's no time limit. Great question, but there is no time limit if the planned crime is capital or life felony. So thank you for that, William. Hey, Crunchy Frog. Forks and Facts. I would certainly check out the playlist for this case. Thank you all for letting me know. Yeah, we've been covering it for a while. We did a really good one yesterday. We covered there was 2 I think this month already. We did one June 19th, which was the Henry Tenon one, July 12th, and then we did July 21st and a July 23rd, and then a July 27th, another one for July 27th. Yeah, and then now today's So the most recent one, which was yesterday, we covered the most recent ones. Crunchy Frog, yeah, it can go back to the beginning, but start by ending date. Even a regular felony. It says first degree felony was only 4 years though. Second and third are, and this is coming from MK Law. So, hey, 80s Music Man, great to see you. Welcome in. Thank you for joining us. Oh, Corey Richins. Yes, Corey Richins. Corey Richins update. Yes, she had a hearing today, and it lasted all of like 2 minutes. So we were talking with Scott. We were talking with RA, and he streamed it, and we were all excited. We were because it was a WebEx, and we had it recorded, and we were going to show it to you guys. After this stream ended, we were going to jump over to that, and it literally was basically. Her new lawyer wasn't ready, so she asked for more time. And it lasted all of like 2 seconds. So if you guys want to see it, Scott streamed it, RA streamed it, and I literally think it lasted like 5 minutes. It wasn't even, let me see how long it lasted. If you guys want to watch that afterwards, you guys can go check out Scott. Let me see, what's he doing? All right. He's on to something else now. Okay, here it is. It started at 1:10, and I say 1:13. It literally was like 3 minutes. Yeah, it was like 3 minutes. So we were going to do that for you. That was going to be something after Corey Richins, but it was basically it's like a 3-minute hearing. So we're not going to bother with it. So and basically it was just to her new lawyer wants more time. Jared, hello, how are you? Carol, does anyone know how old the children are that are in the testimony knowledge of these conversations? Yes. The 2-year-old, well, she was 2 then, she's 6 now, right? This was 4 years ago. And then the twins are 12 now, so they were 8, right? They were 8 4 years ago. So they're asking, from what I can understand from what happened yesterday, it's the 2-year-old, and it probably was on a body cam, and she was probably hysterical and saying, "My daddy fell," and that's what they want to use. That's what the state wants to use. 80s music man. Hi, Mr. Writer, sir. Mr. Writer, Mr. Hell Writer. This is a capital felony. Yeah, they had the DP on the table, and then they removed it. We were reading about that earlier. They removed it, let's see. I think I'll read that again. You would think that I would retain this stuff. Let's see, did they actually say why they removed it? Okay, that's the timeline. Oh, it was after. Was it after Henry Tenon? No, that was that they severed the trial after Henry Tenon. It doesn't say. It just says initially they were seeking. That's why I don't remember. They said the prosecutors said they were initially seeking DP against both, but have since taken it off the table with the support of the family. Let me see if this lead. Okay, here it is. Okay, here we go. According to court documents filed, prosecutors are no longer seeking the DP. Kirsten said in a post, Justice for Jared, that she and her family unanimously support and stand behind the state's decision. Doesn't say why. They considered and weighed for quite some time, so they don't want prolonged suffering for years of appeals, so they basically took it off the table for appeals. So.
All right, thank you. Mr. Fernandez is back with us, and we were going to take up the state's first motion in limine docket line 624.
Yes, Your Honor, thank you. May it please the court. The state's first motion in limine has to do with questions of inmates that the state may call in the trial. And I think the law is pretty well settled here that the state of Florida will not object to questions about the pending case of the inmate. And this stems from the defense's motion to strike the witness that we then tabled and redid his deposition, if the court remembers all of that with regard to the invocations and things like this. So I think that the disagreement between the parties comes down to how much into the particular case that the defense can go. And so the state's position, and we cited Jackson v. State, 25 Southern 3rd 518, as a Supreme Court case in 2009, the defense is allowed to say, you are charged with X, you are facing Y. There is a minimum mandatory in your case. You could go to prison for 100 years. You haven't resolved your case yet. It is still pending. We agree that all those are permissible cross-examination statements. The defense has indicated that they want to go further and say not just what you are charged with, but who is the victim of your case. You are accused of shooting your wife. You are accused of disposing of the evidence of the case, and there is evidence to support you throwing away a gun. That's the line that the state feels like is improper, and the court should deny the defense's ability to cross-examine beyond the nature. The word nature, they cite Henry for the proposition that they can get into the nature of the charge. But actually what Henry says is what I've listed in my motion in limine is what they're allowed to get into. So we agree they can say it's second-degree murder, that he's facing 25 to life. He hasn't resolved this case. He could go to prison for his life. We agree with. What we don't agree with is him saying, and you are accused of shooting your wife and throwing away the firearm, and good facts that go into in detail that are still disputed by the defendant as he's pled not guilty. And the phrasing of this is what the state has accused you of doesn't save their inability to go into those specific facts. Okay. So I think their argument is that, well, he won't even vote because we're just saying what the state's accusing him of. But that still goes into the facts of his case and is not relevant for bias.
Right. Mr. Hill?
Yes, ma'am. Your Honor, I want to let the court know exactly what witness we're going to be dealing with and what we experienced when we were in depositions. This is Emmanuel Alexander. He came into his deposition and told us that he had been in no short of 7 to 10 or more car wrecks over the history of his life with traumatic brain injuries, and his memory was worse after every single car accident. He had had multiple drug overdose and suicide attempts in which his memory continued to get worse. He self-diagnosed himself with dementia, and when questioned, could not remember his conversations with the state attorney's office the day prior to our second deposition, when we had placed the motion to strike the witness on hold in order to conclude that deposition. So we have a couple different issues that are a little more than just simply his bias, but also his ability to accurately remember, which goes to what will be one of the standard jury instructions provided to the jury, which is 3.9, weighing of the evidence, which is going to be whether or not he has a memory to accurately reflect on the stuff that he's testifying to. So, but I want to kind of start back at the beginning because Mr. Mizrahi brought up what we are allowed to question, which we're in agreement. I'm allowed to ask him what he is charged with, what his maximum punishment is, whether he's been offered any favor by the state attorney's office. We have no disagreement on that. I do believe that we're allowed to ask him, and the reason I say this is that we're allowed to ask him, you've been charged with attempted second-degree murder or you've been alleged to have shot your wife. The reason I bring that up is because he specifically states in his sworn statement that was provided in discovery, which would be page 4 of 11 of his sworn statement, it's not been filed with the court, that he states, the thing that made me sour in the relationship with Mr. Fernandez is when he used profanity towards the victim's wife and widow. I think it's important that the jury would be able to weigh his credibility where he's saying, I'm so offended that Mr. Fernandez used the B word and the C word in describing how he felt about Ms. Bridegan, but at the same time, he's charged with shooting his own wife. And so I do believe that goes into weighing his credibility with regards to the jury's ultimate fact-finding. He's not going to be asked to admit whether he did those things because, as I mentioned, he says he has no memory of anything. He said that in an evaluation where he has amnesia, doesn't remember the events at all. He's also been accused by the defense of tampering with evidence in this case. The discovery provided by the state includes handwritten notes by Mr. Alexander, which we believe he's tampering with evidence in our case, and in the case that he has pending before Your Honor in his own case, he also has a tampering with evidence charge, which is specifically throwing the firearm into the woods, which is captured on Ring camera. Again, he says he doesn't remember anything. He acknowledges that he has seen discovery that purports to show him throwing and tampering with evidence by throwing this very firearm into the woods. We believe that is relevant. Our defense to this witness is he's tampering with evidence. He has no memory of his discussions with the state or with other people, and on one occasion couldn't remember a question I asked him 2 or 3 minutes into his deposition, and that he has denied that he tampers with evidence, that he's pled not guilty, and we're not going to ask him whether or not he is guilty. I can envision asking him, do you recall that the state has charged you with tampering with evidence? And he'll say, yes. I imagine he'll say, I recall they've done that. If he says no, we'll ask him, Mr. Alexander, have you seen a video of, in fact, what the state alleges is you tampering with evidence? We believe that's absolutely relevant because the jury's going to have to determine whether he has an accurate memory, which goes to his credibility. As to the statements regarding his wife, I think it correlates back to what he says was so offensive that led him to come and cooperate against Mr. Fernandez, was that Mr. Fernandez used profanity, but the jury should also know that though we're not going to ask him whether he did it, that he's charged with attempted second-degree murder of shooting his own wife. So the jury should be able to weigh that evidence as far as, okay, he says he came forward because he was so offended, but yet he's also accused of shooting his own wife because that is a big conflict in his position. To be offended by words, but in essence not offended by shooting his wife, of which we're never going to ask him if he did that. He's pled not guilty. We have no reason to ask him something that would invade upon his Fifth Amendment right. I did cite, or I did forward to the court as well as to Mr. Mizrahi, but it's stated and cited within the Henry case, which is the Bell case, which the court did allow questions about what charges an individual had, and that defendant tried to invoke his Fifth Amendment right. At the time, the court sustained that. It was reversed and said that those questions were permissible, but they further went on to cite these were matters of public record. And specifically, matters of public record, we have the information that was filed by against Mr. Alexander by Christina Stifler as to count 1, attempted murder in the second degree, attempt to kill Tasha Alexander, a human being, by shooting said Tasha Alexander, and during the commission of the aforementioned attempted murder in the second degree, Mr. Alexander did actually possess and discharge a firearm. So I'm not asking him any questions that are not a matter of public record and do not invade upon his Fifth Amendment right. The state wants to limit it to simply saying, you're charged with attempted second-degree murder, you're facing a 25-year mandatory minimum. They're bringing this witness in who, by their own admission, he's not a great witness, he's charged with terrible crimes. They've not offered him any type of plea deal, he's not pled, but they also want to sanitize this witness so that when the jury hears how offended this witness was by the alleged statements of Mr. Fernandez, they can't also know that he is charged with attempting to kill his own wife. So it seems disproportionate, and they claim that there's some prejudice that they would suffer as a result. In paragraph 3 of the motion, the prejudicial effect of such evidence or inference outweighs the probative value. I've yet to hear what the prejudice is to simply stating what is in the public record and asking Mr. Alexander to acknowledge that that is what he's been charged with. Whether he acknowledges he did it, we're not going to ask that question. The Henry case specifically, though we did cite it in a previously withdrawn motion, that was about asking about plea deals and inquiring into that. And one thing that's important is that that was reversed because there is wide latitude on cross-examination. That's a Sixth Amendment Confrontation Clause issue, and the courts regularly are reminded that there is latitude for the defense to explore because credibility of what is going to be a key witness in the state's presentation against Mr. Fernandez, he should be able to inquire for the jury's benefit as to the nature and specifics of the charges in which he faces. The Jackson case, that was asking this witness whether he that was for a kidnapping trial and was being cited simply to state that the question that we're asking does not establish bias, but it's not limited to bias, as I mentioned. This goes to specifically the weighing of the evidence and whether this witness has an accurate memory. I anticipate he's going to take the witness stand and says he doesn't remember a lot of things. That was kind of a theme of our deposition. I don't think Mr. Mizrahi will disagree that Mr. Alexander, on many, many, many occasions, probably far too many to count, would say that he doesn't remember and would apologize at how poor his memory was, which ultimately led to him telling us that he believed he had some sort of dementia. So I believe that the Jackson case, though it is a Supreme Court case, is isolated to bias. But again, the reason we're seeking to expand upon just asking what he's charged with and simply allowing us to expand on the nature of the charge and the specifics. He's charged with attempted second-degree murder, alleged to have shot his wife, that she is the victim. As far as what's important for the court to note, I do think the Bell case is also instructive, is that the examination is not limited simply to the facts that were pending against the witness. It states that the inquiry can be made regarding the specific nature of those charges. That case has been emailed to Your Honor. It was also cited in Henry, but that's Bell v. State, 614 Southern 2nd, 562, out of the 3rd District in 1993. I think it would be impermissible to allow Mr. Alexander to hide behind just the words of the charge itself and not allow what's in the public record to be asked of him, because he's placed that at issue. Once he said he was offended by the statements of Mr. Fernandez, I do think it's ripe and appropriate for cross-examination to simply state, Mr. Alexander, you've been charged with attempted second-degree murder for allegedly shooting your wife. And that's what's stated in the information, which is public record. The tampering with evidence, again, not to belabor the point, but we did state that we believe the defense of this witness. He will come in and state that he handwrote notes pertaining to this case, his own case, as far as how it included Judge Kite. And we do believe that it does show that he has a history of tampering with evidence. I anticipate he'll do what he did in his deposition when he didn't want to answer a question, is that he'll simply say, I'm sorry, Mr. Hill, I just have a really bad memory. I do a lot of drugs, I've had a lot of head injuries, and asking him whether he's aware, which he did answer in the affirmative, that there's a video that purports to show him tampering with evidence, I think also is appropriate for cross-examination.
Isn't what the defense is arguing almost as if door opening, meaning that it has to kind of occur before you can delve deeper for it to be wide latitude? Correct me if I'm wrong, what I hear, so first issue, he is so offended. I know that might be prior testimony. He may be cross-examined on his reasoning why. Isn't it dependent upon his answer in open court about where you go from there? So it's almost like A and B have to occur before you can go to C, which is kind of beyond and delve in to then impeach or to show additional bias. And so that's my first question. The second question is what I hear you say, which is the evidence tampering. Isn't it also dependent upon, you're saying, well, he's gonna feign a lack of memory, so therefore I should be able to ask on cross-examination, isn't it true that, I don't think anyone is disputing that you can say you have been charged with evidence tampering and it's pending, but then the second thing is now you get to introduce facts. I find, this is my question. I don't believe the rules of evidence would allow you to then go into, and then introduce a fact that is outside of when he feigns or if he cannot remember. Cannot remember is a refreshing situation, is not an impeaching situation. And so then he has to be refreshed about what you're even referring to before he can be impeached with or ask questions about, because the rules of evidence do not allow a party to introduce facts that aren't a part of the universe of facts to somehow impeach him. So on question one, isn't this just a door opening situation? And then it has to happen kind of real time.
So to answer question one, I don't necessarily disagree with the court. However, the state filed a motion in limine in anticipation that that's what would happen.
Right. Okay? So we're in hypothetical land.
So when the state and I and our various teams were in this deposition for a period of 2 days, a lot of the responses were, I don't remember, and we were back and forth with this individual's memory. And with the statements regarding how offended he was about what Mr. Fernandez said. The state asked if we were going to go into this, and we said yes. Hence why they filed this motion in limine. Okay. So I don't necessarily disagree with you. I think the reason we withdrew our motion to strike this witness is we said this may end up being more of a trial issue at this point. But the state then filed their motion in limine, which led us here today. I don't know what he's going to say in trial, but I anticipate he's going to say something to the effect regarding his memory. That's why the tampering becomes relevant. And with regards to his statements of how offended he was, I do think at that point, if that testimony is consistent, based upon the sworn statement he provided to the state, which I anticipate they'll ask him, why did you come forward, Mr. Alexander? You've not pled to your charges. We've not offered you a plea deal. He's going to say, I was so offended by these statements by Mr. Fernandez. When that was made clear that we then were asking him, aren't you also charged with shooting your own wife? How do you reconcile being offended by bad language but not being offended by the allegation that you shot your wife? We didn't go into asking him specifics of whether he did or didn't because he has a Fifth Amendment right, and we didn't invade that right. So the state did file their motion. That's why we're here. That's why we're seeking guidance. I do believe, and we did discuss that we thought it was more of a trial issue once he said whatever he was going to say. I don't know if
I think we have to wait until he says what he's going to say.
I disagree, Your Honor.
How so? I mean,
it doesn't matter what he says. The only way this stuff comes in is for bias. That's it. You can't talk. He's not been convicted of anything. They are trying, he actually said it in his argument just 2 seconds ago, that they can't go further. Let's assume that the witness's response to all of this is, I'm not guilty of that. That's why I wasn't insulted by it. He has a pending case and a Fifth Amendment right to remain silent, and he cannot be impeached based on our allegations. He can be impeached based on the bias that he has because he's facing these time, and that's why that's admissible. He is facing life imprisonment, therefore they're allowed to cross-examine him. Isn't it true you're just testifying to get a good deal from the state? What they cannot do is say, isn't it true that you're not insulted by women because you shot your wife, or under the guise of you're accused of shooting your wife? He has no ability to respond to that. It's a pending case. It's not proper impeachment under any set of circumstances. If he were convicted of the charge, it would not be proper. In the Jackson case, which was reversed, the defense called a witness that was disgruntled with the state of Florida based on the charges that he received. And if you read the Jackson case, they called him, and we are allowed to cross-examine the defense witness that he had he got, quote, walloped with a 25-year sentence, and he thinks he was wrongly accused. Therefore, he has a bias against the state of Florida to come testify. The prosecutor in the Jackson case went further to say, and isn't it true that you were convicted of aggravated manslaughter? And then in closing, the court allowed that, and then in closing said he's a baby killer. And the court said, you can't do that. That has nothing to do with the bias. You can't go into prior cases and collateral impeachment on a witness and opening up a pending case by doing this. So let's assume for a second that he'll say that. I mean, he probably will. He said it in depo. I don't know what he's going to say in trial. But even if he said in trial, I was offended and that's why I came forward, it doesn't give them the right to impeach him on the state of Florida's allegation. If they had some impeachment that he had, I don't even know his situation, he had said previously that he's not offended by people making fun of women, maybe that would be admissible. It's hard to come up with a scenario where it would be, but let's say they have a witness that says he hates women. Yeah, maybe they could call that person to impeach. They said he's insulted by women. But they can't use a charge from the state of Florida to impeach his statement. I don't see a way that that comes in. Thank you. And certainly, I guess I would agree with the court to the extent that this is a situation that we can deal with in trial. I mean, I don't think we need I just wanted to put, when I knew that there was an issue out there that the parties couldn't resolve, I wanted to put it on the court's radar. But I don't see a scenario where it's admissible.
Give me a moment, okay?
Sorry, I was just talking literally to the media, information media request. We're trying to get media passes. So I'm literally talking to their media director. I was emailing back and forth with the media director. So they only have 12 seats in the courtroom for the media. Hoping I get allocated. Hoping I'm one of those 12. All right, so judge is taking a moment to review. I'm not quite sure what, because I was paying attention to that email coming in. So this is about this inmate. This inmate who was in accidents, was doing substances. Sorry, I've got my phone on for when the AC guy calls or shows up. So the state says the only way that this does come in is for bias. So he can be impeached on the fact that he's facing life in prison. So he took out his own wife. So the witness they're calling in, who is an inmate, apparently talked to, overheard, has some kind of information on Mario, and the state is gonna bring him in to testify against Mario on whatever he said. Probably talk directly, because if you overheard it, that'd be hearsay. So I think Judge Kite is probably reading some court case law or something. Crazy Mary Fitz. These trials will be under public media scrutiny, so judge is being deliberate, so to speak. Deb in Indiana, yes, this courtroom does have a very grand look. I commented on that yesterday to Aaron. I'm like, this is a really nice looking courtroom.
Did you all read Breedlove that was cited in the Bell case that went back?
I've read that case.
Did you, Mr. Hill? Breedlove, 580 Southern 2nd, 605.
I see it cited here on the second page.
Yes.
I don't know it off the top of my head. I can pull it up and read it briefly.
I think it's appropriate to stay within the bounds of what is before the court, which is, so as to the first, I think we're just restating what we all know, which is, yes, those are the permissible grounds that you would be able to explore on cross-examination. No one can foresee the future. So to that extent, I'm going to grant the state's motion in limine. If you believe that in some way he has opened the door to additional questions, I think Breedlove gives a little bit, not exactly on point, but Breedlove, at least the Florida Supreme Court, talks about the matters of pending, which we all have kind of dealt with all the time. You have a pending case, the nature of the charges, meaning what is of public record. I don't see any preclusion from you doing that. The allegations that he has, the time he's looking at, I think we're all in agreement. But before the defense goes into basically an equation, that is, I think he has to offer it. He has to offer it as a reason why, his compelling reason. And then, is it in the interest of justice for you to go further than what is normally allowed by law? I think that's a game time decision. And it's generally accepted that before there is an area that you believe a quote unquote door opening, then you seek guidance from the court before you do it. Before you ask the question instead of blurting it out. Breedlove talks about not only pending cases, but also investigation cases. Breedlove also talks about how related maybe investigations are to what is currently being put before the court. And the court, in an analysis, talks about the interest of justice and fairness, and maybe those are considerations that I would take into account at or near the time, but I think we all know what the law is related to cross-examination. It is wide. It's not, there is some curtailing to it based on these issues that are discussed in there. And so what I'm going to grant the state's motion. Before you go outside of what is normally done, Mr. Hill, I'm going to ask that you seek guidance from the court that the door has been opened, and I'll give you the guidance from there. But let him do it. So we don't know what he's going to do, what he's going to say. The state doesn't know. Apparently, you don't know, and so but I'm going to grant it at this point because I believe that to be the current state of the law. And so the impeachment. You can't get to impeachment until an impeachment can come on feigning lack of memory, but there is a showing that's required by the rules of evidence. But you can't impeach, I don't know, or I can't remember until you go through the steps to do it.
And I understand the court's ruling. With regards to the nature and the specific nature of the charges, I haven't seen where this has been specifically addressed, and I'll go back and read Breedlove, but with regards to the 3 charges Mr. Alexander has pending, the charges are stated in 2 different ways on the information. As the court knows, we have the just bulleted, attempted second-degree murder, possession of firearm by convicted felon, tampering with evidence. But then further down, when it actually explains those nature of the charges, I want to make sure I'm clear with the court's ruling.
I think that,
that's just what I want to make sure I'm clear.
Oh, sure. I think that you can go into, you're charged with attempted second-degree murder. And there's a firearms enhancement. All that is fair game. I don't think the state's objecting to that, are you?
I'm not. I think he wants to read the information that the alleged victim's name and then go further. I think what Mr. Hill is asking is to read the information, which I do have an objection to. I don't have an objection for him to say, I'm charged with the attempted second-degree murder and facing a 25-year minimum up to life imprisonment and tampering with evidence. I think the case law is clear that that's admissible. But he's starting to talk about who the alleged victims are, and that's the facts of the case. For all I know, the witness could be saying, I've never met that woman a day in my life. I don't know why I'm charged with her. I don't know who she is. I didn't shoot any women.
And that may be his answer.
Oh, but that's the
I don't know.
point is we're getting into a charged offense where he has a Fifth Amendment right, and it's not relevant to any material issue in the case. The material issue in this case is whether or not he's biased, and the charges and the amount how much time he faced goes directly to that, and that's why it's admissible.
So in Bell, the 2 questions that were posed to the witness where it was found that the Fifth Amendment was the court should have allowed the answer. It was, you've been charged by indictment of X crime. That has been, basically, the witness should have been permitted to answer that question. I can go, hold on.
Same thing.
You're not going to suggest it because he hasn't been charged.
No, you can talk about you've been arrested as well, and it's pending. I agree with that. You can't. Yeah. You can't go. My objection would be you're charged with your children. Yeah.
I can go back to Jackson, but maybe we're splitting hairs, but saying you plan on reading the information to him?
So again, this kind of goes back to the court's first question. We're kind of going off what we anticipate his answers may be based upon his lack of memory throughout his deposition. There was some confusion for him as to what he was actually charged with. He would have to consult with his lawyer.
Really?
Yeah.
Well, I don't, right now, where I'm at is that ask the normal questions. We have to see, I guess, what he decides he's going to end up doing. If he if he I keep saying feign, if he says he doesn't remember what charges that he has, then, I mean, then they can go up with the information and put it in front of his face and say, you haven't seen anything like that, and they can start reading from it. They can do all kinds of things, and I think we're too far afield into hypothetical land. Right now, I'm going to grant the state's motion. We'll see what he's going to do. And it's going to be a game time decision about how far they can go or not. If he's going to be that, from what y'all are describing, if he's going to be that uncooperative, I think that they can go through the normal means to either refresh his memory, to ask him questions.
I don't, that's a different, if he says, I don't know what I'm charged with, that's a whole different ballgame.
I mean, I don't know. So, and y'all don't, it doesn't seem like y'all know, so.
He says he doesn't know. I've never said I don't know what the witness is.
Okay, well.
I don't know what any witness is ever going to testify to.
Right, well, I'm just saying, I think that we're getting too far, like, could that happen? Yes, I think so, but right now, I'm within the, ask him the normal questions.
I understand, Judge.
Okay.
They filed their motion, so we had to.
All right, no, I get it. So at this point in time, is granted without prejudice to re-raise. Okay.
Thank you, Your Honor.
Thank you. Is there anything else for today?
No, Your Honor. We can. Your Honor, the defense filed a judicial notice request of Your Honor.
And I saw there was an objection.
We objected to it, so.
It was about the firearm, right?
We simply want the court to take judicial notice of the fact that the FBI used that firearm from whatever it is, 1986 to like 1996. For the purposes of today, it doesn't matter. Ironically, the state doesn't disagree that that is a fact. They don't disagree that the FBI used that firearm and then discontinued it. What Mr. Mizrahi, as I anticipate, although today he keeps telling me I'm wrong, my anticipations is they want more information. They want the jury to know that it wasn't the greatest firearm. It didn't work good. It had high recoil, whatever the case may be. And as Mr. Mizrahi said to me, facts that come in as judicial notice have to be facts that there's no disagreement upon. And ironically, the example that he gave me was it's 72 degrees outside. That would be something the court could take judicial notice of. But neither party disagree in this case that it's 72 degrees outside. What Mr. Mizrahi tells me is, yeah, but I want to know more. Well, maybe it's 72 degrees outside because of global warming. That there would not be an agreement on. Maybe it's 72 degrees outside because there was an extreme heat wave in Alaska. That would not be. But the very idea that it's 72 degrees outside, stop. The state does not disagree. And what it says is facts that are not subject to dispute because they are capable of accurate and ready determination by resort to sources whose accuracy cannot be questioned. I provided them with a letter from the director of the FBI when they started using the firearm, and I provided them with evidence that the firearm stopped being used. And they don't disagree with my sources. They have told me they don't disagree that they're experts and the people they've consulted with and the gun enthusiasts in their office all know that this is a fact. They just don't like that that fact alone is coming in. They can call anybody they want to put in whatever information they want about the 10 millimeter. I just don't want to be in a position to have to pay somebody, although I've already listed somebody from the FBI who I will call on Zoom to put that fact in if I have to, when there's no dispute as to that fact. I'm not preventing the state from putting in other facts if they so choose. If they're going to call someone from the FDLE who's a firearms expert, and they're going to say, what was the problem with the 10 millimeter? It had high recoil, it had high velocity. That's it, fine. Maybe if they know something about the 10 millimeter, I'll get a bunch of testimony out that it's not all that rare of a firearm. Millions of them are made and every manufacturer has made that firearm. I'll take advantage. But it is not subject to dispute that it was the issued standard firearm of the FBI from 1989 to 1997.
Okay. Thank you.
And our objection is multiple faceted. I think the notice was asking that it was a 10 millimeter. The 10 millimeter, in regard to this case, our firearms expert would testify that it was a Glock 10 millimeter. The FBI firearm was a Smith & Wesson 10 millimeter. These are the kind of nuances. What the defense is asking you to take judicial notice of is essentially DNA is unique between everyone except identical twins. These are not facts that typically are judicially noticed. While I agree that the FBI may have had, and they in all likely did, issue a 10 millimeter firearm during the specific years in question, that is not a statute or a regarded temperature at a particular time. And so we don't think this is appropriate for judicial notice, and would ask the court to deny it. And certainly the defense has already listed somebody that can certainly cross-examine any of our witnesses that have the information about what the FBI may have had. I don't see this as an issue that needs to be judicially noticed. It won't take any more time from the jury. It's not a complicated issue. You know, judicial notice is usually about, these are the laws of Kentucky. You know, this is the registry of something. You know, the person was on probation, whatever the case may be. So I don't think this is appropriate for judicial notice. We have objected to it and thinks that kind of evidence that needs to be presented is evidence that should be subject to cross-examination.
Okay. Mr. Dreiss, I'll give you last word.
I don't have anything further.
Okay. All right, I'll issue an order on it. All right, thank you. Court's adjourned.
Our next court day is Tuesday?
Dang it. I wanted to hear their next court date. All right, so that's it. All right, don't go anywhere. Since we're not going to do Courtney, I'm going to, this will be perfect. We have, because I don't know if I've shown this or not. Oh, and then huge breaking news. We just heard that Courtney Clenny has taken a plea deal. So there goes that trial. That's coming out of Miami. We were going to cover that trial. We've done some deep dives on Courtney Clenny and Christian Abuncella. And that Courtney Clenny has taken a plea deal. And I believe that came from Catnat Williams. If you guys are not familiar with Catnat Williams, that came from there. So Courtney Clenny has taken a plea deal. Not verified yet. Oh, Courtney, not Corey, sorry. Yeah, wait. Courtney Clenny is taking a plea deal. Yes. Did I say Corey? Sorry, guys. Obenselli, yes, Christian Obenselli. So Courtney Clenny. Did I say Corey? No, Courtney Clenny. Courtney Clenny. Now that's coming from Catnat Williams, so we'll have to wait to see more evidence, more proof that that was the case. But that is apparently what's going on, what's going around right now. All right, so I wanted to play. Oh, since we're not doing Courtney. Yes, since we're not doing Courtney. Since we're not doing Corey Richins, I'm going to play a little bit of extra here. And I'm going to play Shanna's getting arrested. And this is only about 40 minutes, and then we'll be done for the day. Because I theoretically have AC techs coming. They were supposed to be here between 12 and 5. So... All right. So this is from August 17th. It's from August 17th.
.26. They're making contact at the front door right now. These officers inside, okay?
I'm here, Shanna. I'm outside. Oh, they're gonna call you. Oh, yeah. And you want me to go get your shoes?
Take what she has, and then they'll order more if they have to. Yeah. Okay.
Do you want to get all my medications that are in the bathroom on the counter and in the drawer under the light seat? Okay. And then the
we'll just need to see like if it's valid.
Well, the Advair is like a disc that you inhale the ozone powder, and it doesn't have the persistence on it.
Yeah, a medical person that will evaluate. You guys smiling for the brain camera? I got one good smile. She's in the bathroom changing. So they're going to need the prescriptions in their pill bottle.
I've only got one day in your pill cabinet, Shanna. In your bathroom. Okay.
Yeah, I just don't know. I didn't know what they. Want to just throw them in there? All the properties need to be taken. Grabbed like 5 of those yesterday, and I'm out.
Shanna, are there 4 of them?
We'll follow you there. Can we get her on the interview? Yeah, they should have some in there. I'll let the COs know. Probably gonna have to do the booking process, and then it should be good to go. Maybe I'll take her to the PD first. We could transport her to our PD. And... That's what I'm saying. Can we get her to the PD first? Oh, okay. I thought the jail. We'll try, right? Can I email you the form? I think she's using the bathroom. Too. I guess pills only, I think. It's gonna be the white vehicle back there. We'll go to the passenger side. Yep.
Stop.
Is that property?
Medicine. Good?
I'm good, thank you.
That's your medicines. I don't know what y'all want to do with it, but most of them are prescription. So we'll follow you over to...
So, the detective was saying going to the PD, we do have interview rooms.
Perfect.
Within the PD, so we could take her over there.
That's, yeah. That
pull
works.
her out.
Yeah, if you want to bring her there, and then we'll follow behind you and we'll go interview.
Okay. So just a heads up, I don't know if the jail is going to take anything not in the bottle. Okay. Otherwise, it will looks like everything else is good to
I'll
go.
leave y'all up to whatever you guys decide.
We could try, but I think the jail will probably say no to that.
That's fine.
This is West 30. Could you pass me the SP primary, please?
So remember, her family has lawyers. Like, the family has lawyers, so they're probably just telling her, just go, we'll take care of it, we'll get the family lawyers, etc., etc. So that's probably why, you know, we heard earlier that the family has lawyers.
This is West 30. I just wanted to let you know I do have one female in custody, and I'll be transporting her to the jail, or to the PD. Yep. 1 second. Mileage is 10.1. Perfect, thank you.
I don't think there's going to be much talking. If he talks, I'll stop talking. But so, okay, so some information we learned. Yeah, so the kids are still with the grandparents here in Washington. They are 12 years old, boy and girl, male, female. I'm not going to say their names, even though it is out there. Their names are out there. If you want to go find them, their names are out there. But I won't say anything. Is he actually talking? So yeah, so I would think her parents are like, don't talk, don't say anything, we'll get you lawyers, you know, because we heard that earlier that the family has lawyers. Of course they do, you know. So, let's see, what else can we talk about here while they drive? I mean, I could fast forward through all this too. So they were married, Shanna and Jared were married in April of 2010, Salt Lake City, Utah. They were married for 5 years before separating. They filed for divorce in February of 2015. They have twins who are 12 now. So again, this was 4 years ago. Yeah, 4 years. So this happened in February of 2022. She's arrested August of 2023. As you can see there, August 17th. I think Mario was right before her. I think he was the day before. Excuse me. And remember, they found Henry first, and then Henry led them to Mario, and then Mario led them to Shanna. Kimbers, welcome back, welcome back. Hey, there you are. Yeehaw, you are back. Oops, wait a minute, sorry. I'll pull that up in a second. I wanted to pull up. There, that's what I want to pull up. Kimbers, yeehaw, you are back. All right, Vicious says, I knew the day would come that she was going to get arrested. All because she didn't want to share custody. Apparently she didn't like the way Jared was raising the kids. I don't know if there was anything else going on. We haven't heard that aspect of it. All we know is that the state's theory is the motive was she wanted sole custody. She wanted Jared out of the picture. I don't know if there was any insurance involved with this. Not sure about that. There could have been. There could have been some kind of insurance involved with it, but it was definitely over custody. That's what the state is going with. All right, I don't think there's going to be much talking. It doesn't sound like they're not. She's not talking. So I'm going to fast forward through some of this. Let's see. Let's actually get, all right, here they're coming. We'll come to here.
I think my cage camera's not working. So I have to get my body cam on. Can I open it? What? Body cam will be turned off in the back lot of the PD where cameras are in view. Yep.
So different kind of body cam. I get it. Different kind of body cam. Ruth, this is where you live. Wow. So different angles. Same. Obviously, same arrest.
Can I be with the kids, or can you at least bring the kids out to me?
Yeah, we'll have to talk to these officers inside, okay?
Marlon, my neighbor, has temporary.
I'm here, Shanna. I'm outside.
Oh, they're gonna call you.
You want some shoes?
Oh, yeah, probably. Can I?
Get some shoes for her.
You want me to go get her shoes?
I'll get her shoes and all. Here's the food and shoes for her.
To the front if you want.
Yeah, that's definitely her mom. I'm thinking that's her mom sitting there, right? Is that her mother?
Yep.
Is that okay?
So I'm still good with them. You guys good with them going back in?
You can go with the kids.
Yeah. Thank you. Oh, sorry. Do you want me to go to your pants? Which ones want your jeans? Yeah. Yeah, is that okay? Is that okay? It's fine. Okay. Abby? Oh, no, right. I'll say, you have orders on the Instagram that I was managing for you. You have orders to just have grandma help you get into. Where are your jeans, Mom? I know where they are.
So her kids would have been 8. They would have been 8 years old. But she's talking to her kids right now. They would have been 8. Hey, Christine, welcome in. How are you?
They're on my counter in the bathroom. Are those the jeans? It was on the box. The Advert,
They let her take prescription medication to the jail with help. Where is that?
Yeah, they'll let her take what she has, and then they'll order more if they have to. Yeah.
Do you want to get all of my medications are in my bathroom on my counter and in the drawer under the right seat? It has a box that I don't have, but I mean, you guys call my doctor.
We'll just need to see like it's a valid. Jail has a medical person that will allow you
Okay.
to deal with all that
Okay,
stuff.
perfect. Yeah. Stop here.
You guys smile.
I think I have one good smile.
We're gonna bring you inside real quick. Get you out of the warm car, right? Step out for me. We're gonna go through these doors over here. And then there's gonna be a hallway to your left there. Have you take a left there for me. And we'll go down to this last door here on the left. Have you stand there for me. And I'll have you take a seat over here. And what I'll do, actually, if you want to face the wall for me. So
what I'll do is I don't want to keep you in these cuffs for a long time. I know they kind of hurt. So what I'll do is I'll take one hand out, and I'm just going to attach it to the railing right there, all right? Yep. Do you want to take that hand, place the top of your head for me? If you want to step to your left or turn the other way, I'll have you take a seat.
Yes, sir. Sure.
Turn the other way for me. All right. And then if you want to take a seat for me. No, you're okay. I'm just going to scoot you a little bit. There you go. And then the other officers will be in here shortly, all right? Do you know, I guess it doesn't really matter, but I was going to say that pulling up the camera footage, but I can just stand here, so. Chair? I'm good.
I'm just going to kind of fast forward through some of this. Waiting for something to happen. Is she going to come out of here? Oh, there she is. Okay. See, that's what I get for fast forwarding.
Which one's tight?
They're both tight. The right one's more than.
The right one's more tight? Okay.
But it's okay with these.
I'll loosen it a little bit.
Sorry.
Are those cuffs putting any strain on your shoulders or anything?
Alright, but it's okay.
Okay. Well, I'll get you down to jail as soon as possible, and then we'll get you out of these cuffs.
How far away is the jail?
Probably about 10, 15 minutes.
10 minutes, but there's a bunch of construction, so.
I feel bad. Do you want me to grab this and put it in the trash?
No, we'll get it for you. That's all right.
Do I need to take my water?
Do you want any more water before we go?
Sure.
You want a little bit left? Good? And then we'll just go back out to the same car we came in. It's this one on here on the left. Yep. And then what I'll have you do is I'll just have you face the numbers right here. Just because you were in that room, I am just going to pat you down. Just to make sure nothing else ended up in your pockets. And then I still do have your medications with me.
Okay.
So those will be checked into the jail.
Okay.
Just want to have C for me. I do have a question for you. It's not regards to the charges at all. Those the medication that's in that little divider.
Yeah.
What's in those?
I can tell you.
But she is on a lot of medication. That's a lot of meds she's talking. These are all the medications she's talking about. I'm not on any meds.
Just the reason I asked is because the jail might not take that divider.
That's fine. I
I don't
have
know.
enough in the bottles.
Okay.
I think there was only a day left, is what my mom said.
Okay, and if you have them in the bottles, then that's good. I just saw that in there, and the jail is pretty picky on prescriptions
Yeah,
they'll take.
no, I figured the divider my mom can come and get,
And then I am just going to read you, just since I have you in my custody. I don't know what the detectives asked you. I'm just going to read you something. So you have the right to counsel at this time. If you're unable to pay for counsel, you'll be entitled to have one provided without charge. Do you understand that? Okay. And that's it. So I'm going to put your seatbelt on. I'll get you down there. It's hot. So hot my vehicle can't keep up.
I say it's hotter for you guys wearing all the stuff you guys have to do.
And I'll get you down there so you're out of cuffs. I know those are uncomfortable. So just sit tight for me, all right?
What's the matter? They belong to ATF?
I think they're detectives, Jacksonville.
Oh, okay.
But
you got your warrant?
Yeah, I got the two. So I have these two, it looks like. This looks like another part of the warrant here.
Hey, if you need something, give me a call.
Okay.
Yeah, give me a call.
Alright. Well, he gave me his business card, so if I have some type of document issue, I'll give him a call.
Okay.
I'll also give you a call.
Sam's good. Just contact me.
Hey, this is West 30. Could you pass me to SP Primary, please? All right, thank you.
This is West 30. I was just calling to let you know. I have my in custody back on board, and I'll be en route to the jail. Starting mileage will be 13.0.
Perfect. Thank you. Bye.
Pretty much it. He drives off. All right. And he just drives off. So, all right, you guys. I am. Oh, Edwadi, how are you? Great to see you. Thank you for the gold coin, 10 jewels. Thank you so much for that. I really appreciate that. Thank you. All right, I am going to sign off because we have our AC tech should be coming here anytime. He was supposed to be here between noon and 5, and it's 3 o'clock. So I'm hoping he shows up soon because we definitely need AC in the house. So I'm going to wrap it up. I'm going to start working on my Lindsay Clancy. We're going to do a stream on Sunday. Every Sunday while the trial is going on, we're going to do a recap. So starting this Sunday, today's Friday, so 2 days from now, probably starting at noon, we'll do recap. So I have to get prepared for that. And then the big news is it looks like Courtney Clenny has taken a plea deal. So those are some big things that we have to work on. So Sally, thank you for the $200 jewels. Really appreciate that. Thank you so much. Yes, have a great weekend. I know AC is going to be running. Trust me, I know. All right, so that's going to be it for now. I do have, like I said, I'm going to work on Lindsay Clancy for now, and then wait for tech to show up, and we'll let you guys go. So go out into the wild. Go out into the wild. Enjoy the rest of your Friday. Thank you so much for watching with us today. Really appreciate you spending your day with us. We have Mario Fernandez and also Shanna Gardner coming up. Sarah Grace Patrick is coming up next week. So we have lots of really good, interesting trials for you guys to watch. So with that, have a fantastic rest of your day. Please do something positive for yourselves and for others. And thank you to our mods. Thank you to Aaron and Grampy. Super Ball is nowhere to be found. I have no idea where Super Ball is. So I can't show you. I can't show you Super Ball. She's nowhere to be found. So hopefully we'll see you guys on Sunday, as Kimber says. And Vishy, you are more than welcome. Thank you for joining us. Really appreciate it. Thank you, Shirley. Thank you, Gina. All right, you guys. Jennifer, yes. May the AC odds be ever in your favor. Thank you. Really appreciate it. All right, guys. Have a great one. And I'm pulling up a bunch of stuff. We'll see you tomorrow. No, Sunday. Sunday. Join us Sunday for Lindsay Clancy. We'll look back at the week and we'll see where that takes us. All right, guys. Take care. Have a good one. Bye.